I see that your video and microphone are on, Jane, but I can't hear you.
Oh, Bob, do you want to go and get Charlie to come into the meeting? Is he going to get Charlie? Okay.
We're the wrong generation for all this technology.
And I'm stuck at home as well, so
Yeah.
it's a three-way carry on going on.
Yeah. That sounds like it.
Oh, is that
Can
working?
you hear us now?
Oh, perfect.
Oh,
there
great.
we go. My expertise fixed it. Try every button on the machine and see what happens. Excellent. Well, Graham, if I put us on mute now. Okay.
Yeah.
That means that probably means that I'll have to use this one, Charlie.
Yeah, maybe.
Well,
yeah, I think so.
Yeah.
And you've got it there.
Okay. Cool. All right. So, thank you.
Thank you.
Thanks, Anna.
Let's start the hearing. So, tēnā koutou katoa, and welcome to the hearing this morning. This is, we are here to hear an application by Anderson Branch Creek Limited for a 5-lot subdivision at Branch Creek Station, which is located on the Cardrona Valley Road. The commission this morning is myself, Jane Taylor, and Bob Nixon. We are independent hearings commissioners, as I think all of you know. Just briefly, I don't think we've got any members of the public attending this morning, but just in case there are some online, just to let everyone know that the order of the hearing today will be, first we will hear the case for the applicant. There are no submitters for this application, so we won't be hearing from any submitters. We will then, once the applicant's case has closed, we will hear from the council officers who will speak to their reports and comment on the evidence that they have heard this morning. And then we'll have the applicant's right of reply. Now, I say that subject to, I think the first thing we need to do is look at the jurisdictional matter of scope, but I'll get to that in a minute. I won't run through the meeting procedural rules because that's obviously only intended for those that are speaking at the hearing, and I think everyone here is very experienced. I don't think I need to go through that. In terms of the council officers present, we have Mr. Jacob Neves and Mr. Richard Denny, who are at the top of my screen. Good morning. I think Mr. Jones is with us as well, who is the engineer. Mr. Neves, are you expecting any other of your experts to be attending this morning?
Just myself, Richard, and Ken.
Okay, great, thank you. We also have Trish Anderson, who you all know as well, who's listening in and running the meeting behind the scenes. We can take the agenda as read. So we have had the original application and the AEE. We have the council's section 42A report. We confirm that we have received the applicant's pre-circulated evidence and we have read that, so we can take that as read. And we've also, Mr. Todd, thank you, had your legal submissions, which we have had a read through as well. Just one matter I just wish to raise now on the section 42A report. Mr. Neves, on page 34 of the actual, and I'm referring to the pack that got sent out, so it's, I'll find it. think it's page, I'm not sure which page it is of your report, but it's headed up overall conclusion. So it's at section 8.3.2 at the end of the PDP assessment. And you say in the first sentence, I consider the proposal to be inconsistent with key objectives and policies of the PDP and contrary to the most relevant ONL objective and associated policies. So can you just tell me which one of those, is that policy? I think actually on second thought, I think I read that as ODP, but you're actually saying ONL policies, which is, I think you're referring to
Chapter 6.
6.3.3.5, is that right?
Yes, I believe so.
6.3.3. Is that, have I got that right? Yeah.
Yeah, chapter 6.
Okay. That's right. Thank you. That I just had that question in my head, so I thought I'd just clarify that. Thank you. Well, do you have any clarification questions?
Not at this
Not
stage,
at
no.
this stage.
Well, we're happy to wait for Mr. Todd to proceed.
All right, thank you. Are there any other matters that you would wish to raise, Mr. Neve, outside of the jurisdictional issue, which we'll get to soon, but just in relation to your Section 42A report?
No, nothing at this stage, thank you.
Okay, thank you. Yesterday, Mr. Nixon and I conducted a site visit, which was probably rather challenging given the conditions on site, which we hadn't anticipated because there is no snow in the valley over here in Queenstown, and of course it's probably about a foot of snow over there. So fortunately we had an appropriate vehicle, so we did manage to drive up to the site, and I think we have a pretty good appreciation of the site. We also managed to stop and walk across to proposed lot 1 as well, so we did see that. The only piece that we probably would have done if there hadn't been snow is sort of walk between that lot and up to proposed lot 2 on the side of the hill. So obviously we didn't walk up there, but most of the assessment is from the valley floor and the road as opposed to being up on the site. So, but other than that, I think we got a pretty good appreciation of the site. And we probably should have looked at the weather before we left, or the amount of snow on the road. But anyway, it's that's all good. All right, so we'll now turn Mr. Todd to the applicant's case. And so thank you very much for the legal submissions. Given that the application has changed reasonably substantially since it was assessed by council, I would just like to you to take us through your submissions in relation to scope first, and then I'm going to ask the council officers for their views on the changes, the scope issue, and whether they have been able to assess the changes, and then we can consider, in light of that response, how we proceed. So I will hand over to you. Thank you.
Thank you, Madam Chair, Commissioner. Thank you, first of all, for setting the context of the application by having the photo of the Cadrona Hotel immediately behind you.
Oh, right. Okay.
Very, very appropriate that we set the scene.
Yes.
And I wonder if it's not helpful for you, both during this discussion concerning jurisdiction and also generally during the hearing of evidence, for you to have before you both plans, the layout of the actual subdivision, and you will find the original plan contained helpfully within Mr. Neve's report, because of course that's what he was reporting on at the time, and that is immediately preceding. Unfortunately, my copy of the report is not numbered. The pages are not numbered, but sorry, yes they are. Page number 5 I think,
That's
it is.
right. Okay.
And it's immediately above the section 2.2 of the report.
Yes. And I think we have that in front of us, I think, from the original survey plan. So,
Yeah, so that shows the layout originally proposed, and importantly, what is shown as the building platform for section 8 is consistent with what is now proposed lot 1.
yes.
And the significant difference is in relation to the relocation of what was the 3 lots up on the terrace riser or the escarpment. 2 of those have been relocated to the floor of the valley behind the existing dwelling, the neighboring dwelling on lot 1. So, and then we now have a balance, including a building platform for a balanced allotment being lot 5.
Right.
So, so in summary, if I can just take you through, which I have at paragraph 23 of my submissions, it's my submission that you do have jurisdiction. First of all, we obviously are subdividing the same piece of land, or proposing to subdivide the same piece of land. Secondly, the proposal is for a similar number of lots and residential building platforms. So there's no change in those numbers, or no, and more importantly, as far as jurisdiction is concerned, no increase in those numbers. The same number of vehicle crossings are proposed, albeit that the use of those will be redefined in terms of the fact that now the majority will come off the existing crossing point, and only 2 will come off the proposed new crossing point. And generally, it is my submission that, given the findings and recommendations of Mr. Neve's report, which is based, of course, on Mr. Denny's peer review, it is my submission to you that potentially the effects of the subdivision are less than that might have occurred in terms of the original layout. So, given all of those matters, it is my submission to you that you do have jurisdiction. And in terms of how the court normally considers these matters, it's a question around whether or not there might be somebody out there that might have made a submission that hasn't done so. Might they have done so if they'd known about the new configuration? And it's my submission to you that that would not be the case, because we don't have any submissions, and B, the evidence that is part of the basis of the applicant's case, and which can be confirmed by Ms. Anderson, who's in attendance, who I'm not intending to formally call, but is available to answer any questions. It has been her instructions to us that she is not aware of any use of the unformed legal road, where you might suggest that there might have been, if that had been for example, a form track, given that the building platforms were going to come closer to that unformed legal road, that might have caused some issues around jurisdiction. So, notwithstanding that, the fact that anybody that might use that track in the future would or may have at some stage in the past that we're not aware of, will have had to have passed the existing homestead and farmstead to be aware that there's something going on there anyway. So, and other than the repositioned building platform on the now proposed lot 4, the building platforms are set well back against the terraced riser. And therefore, it's my submission to you that it's unlikely that anybody would have raised any concerns. It's another factor to be taken into consideration is that the poles on these new lots have been in situ for some time. We're not aware of any inquiries that have been made from anybody as to what they might identify or delineate. So it's my submission to you, based on all those matters, that you do have jurisdiction to hear the application as noted in my submissions.
Okay. Oh, thank you, Mr. Todd. Just in relation to your comment about the same piece of land, we might as well bring this into this discussion, I think, but I have to say I am a little confused. I think there has been since the, I think even since the Section 42A report, there has been a further boundary adjustment in relation to, I think, what is now proposed Lot 1. And I think we don't have a clear picture of the entire property. I don't think we have any plans that actually show the station and in its entirety, and how these parcels of land actually now fit within the station. So I have to say, for my part, I'm a bit confused, because it appears to me that we now have Lot 1 so anyway, someone could take us through that. Thank you.
Yeah, I could possibly, and Mr. Vivian may be able to assist in that regard. But my understanding is, if you look at the original layout,
yes,
you will see that you are correct, and it appears that all of the land shown within that layout or that aerial forms part of two blocks of land, taking out the Lot 1, which is the existing, what is noted as the existing homestead.
Yes.
When you turn to the reconfigured allotment, which is on the Aurum survey plan, dated the 1st of June 2022, up in the top left-hand corner, you'll see that there is a yellow line which runs effectively to the west of now proposed Lot 1.
Yes.
Now, that line, you'll see immediately to the left of that, or that boundary line, you'll see reference to Lot 2, DP 546120.
Yes.
That is the land that has been the subject of the boundary adjustment, with the neighbouring landowner being Cadrona Valley Farms Limited.
Okay.
And so that land has now been taken into, and on your site visit, you may have seen, or you won't have seen actually because of the snow, but that when I was on site, that land had been ploughed. And so, and you can almost see on the aerial photograph where that has occurred.
Oh, yes, I see.
Immediately left. So effectively what happened and then to explain further how this site fits in, to the east, you'll see the unformed legal road, which is the one that is referred to quite extensively in the various reports.
Yes.
To the east of that again, you'll see reference to Section 19 Survey Office Plan 467007.
Yes.
That is the neighbouring Crown Pastoral Lease, which is owned, or the family is the lessee of that part, the Anderson family are the lessee of that. So effectively what they own is a freehold block of land, which effectively is shown, the mouth of which is shown in both aerial photographs coming out to Cadrona Valley Road, and it runs in a northerly direction, the freehold parcel in a northerly direction, to encompass the total 21 hectares that is the balanced Lot 5. You'll see 21.637 hectares.
Yes.
And then there is a further parcel further north of that again, and then of course, the majority of the Anderson Branch Creek Station is held within the pastoral lease, and that's some 6,000 hectares.
Just to clarify that, because I'm still not quite clear. Lot 2, which is south of lot 1, where you said that is that part of their land, or is it?
No, it was previously part of their land, Commissioner, but it has been the subject of the boundary adjustment and is now part of Cadrona Valley Farms land, and that portion being lot 2, 546120.
Yeah.
So you'll see that there's no boundary shown on the original subdivision scheme plan.
Yes.
And that has subsequently occurred.
Yeah.
Remembering that this application was originally filed in 2018.
Yes, I'm right.
Now, taking all that into consideration, what I have said in my submission is that the land that is being subdivided is consistent, subject only to that land having been taken off for the boundary adjustment in terms, but none of the land that was proposed to be subdivided in terms of directly subdivided in terms of the original application, it's all still consistent other than that's been taken from the boundary adjustment. So, and most importantly, the building platform for what is now lot 1 is in the same spot as it was for what was previously section 8.
Yes. Okay.
Okay. Just continuing with that. So section 19 to the north, that's the one you said is leased.
Crown
Leased,
pastoral lease, yes.
That's a crown. It's a pastoral lease. So the Crown owns the land, and the family has, under a pastoral lease, they have perpetual rights of renewal in respect of that land.
Okay.
Leasehold land.
And in terms of their freehold land, at present, presumably they own everything between the Crown lease land and the Cadrona land, but they're proposing to dispose, if this application is approved, lot 1, lot 2, lot 3, 4 and 5 will be sold off as lifestyle lots.
Well, four blocks will be sold off as lifestyle blocks. Lot 5 will be part of the remain of the effectively balanced title, which is 21.63 hectares. And you're correct, other than to say that they own all the land except what is the existing homestead lot 1 DP 151386, which is shown there. They don't own that.
Okay. So, Mr. Todd, so the piece that was
And
affected.
can I just say that land is the land that is owned, sorry, that site, the existing homestead, is the site that was owned by the submitter who originally submitted an opposition.
Yes.
Yeah. Okay. So Mr. Todd, so when the land went through tenure review, then was the only piece that was freeholded effectively taking out that existing homestead lot? Is that all?
No. There was always two. There's never been any freeholding. So
Okay.
the pastoral lease is the pastoral lease. It
Yes.
remains the pastoral lease.
Yes.
The other land was always, as I understand it, freehold land.
Okay.
And so what has occurred in the past and up until now is the existing homestead was subdivided off
Yes.
and sold. And secondly, the boundary adjustment, which we've talked about in favour of Cadrona Valley Farms, has occurred. Other than that, nothing else has occurred. And I should say, I should have said, for way of further background for you, that all of this is occurring as a means of farm succession for Ms. Anderson, who was present, to effectively take over the family farm. And this is a means by which she can obtain that.
So when you refer to the family farm, is that now, so assuming this is, or if this was to be granted, so
Yes.
that effectively then there will be no freehold land left that's part of the farm. And
Yes,
so
there will. No, yes, there will.
Oh, there
Yes,
will?
there will.
Okay.
There'll be lot 5
Oh, sorry, lot 5, yes.
and an adjoining piece of freehold land, which is further to the north.
Okay.
Okay. So up until now, our understanding was that if there was going to be a new farm base, it would be on lot 1, but that's no longer the case, is it? It's now
No.
going to be lot 5.
No, that is well, no, the actual farm base, the farm base for the actual farm is on the pastoral land, and it's up another valley further towards Wanaka.
Yeah, I thought that must be the case because there really is no farm infrastructure on this.
Yeah, we did wonder about that.
I mean, there's a little bit, but there's not a lot. And so for a large station like this, obviously, I do have a farming background, so I know a little bit about farming. I would wonder where some of that was. Well, I think what would be really helpful at some point this morning, if we could have a plan of the entire farm, including and just with these areas marked up, so we can actually put it into the context of the working station, because I think that is quite an important, and it is referred to in your submissions, but it just gives us a bit more context around that. Because of course, one of the questions was, well, before we went to the site was, well, what's going to happen with the farm infrastructure? But obviously, it's not here. So, so that's.
Now, I should raise one other issue for you.
Yes.
You will note on the new configuration, and I was wrong when I said there was the same number of lots. There's actually a little lot called lot 100, which is shown as within the boundaries of lot 3. Can you see that?
Lot 3.
Yes.
Yes.
I can see that.
Now, there's a very good reason why that needs to be created. You may be familiar with the new legislation that was introduced last year called the Water Services Act. And the Water Services Act is intended to impose obligations upon the supplier of any potable water, which obligations are quite severe. And there has been a lot of submissions made to the government as to the implications of what they've done. But in effect, where you have what we commonly refer to as a shared or a community water scheme, no longer do the users of that scheme share the responsibilities for it. The full responsibility in terms of that water scheme will fall to the supplier or the person upon whose land the water source is located. And it has major implications because they are ultimately responsible. There is any contamination of the water. They are responsible if the well dries up to continue to supply potable water to all users of that scheme. So what we've done here is try to anticipate that problem by creating a small lot of 30 square meters, which will surround the actual water source. And it is intended that all owners of the individual lots will have an undivided share in that, and there'll be an amalgamation condition requiring their undivided share to be held with their freehold allotment. So, for example, the legal description for lot 2 will be 1.994 hectares, more or less, being lot 2 deposited plan, whatever the number is, together with an undivided 1/6 share in lot 100.
Yeah, okay.
And it solely means that we now can impose the obligations under the new Act upon all owners, rather than it being upon one of the owners, being the owner of lot 3, because otherwise they would have carried the full obligations imposed under the Water Services Act on behalf of everybody else, but they would bear all financial and regulatory responsibility for that. This new act is going to cause significant problems.
Yes. So how does it apply retrospectively then? Because I mean, there are hundreds of these schemes. Yeah.
It doesn't matter. It does apply retrospectively. If you have the water source on your property, then you have full responsibility and and you cannot contract out of that responsibility.
Gosh.
This is all part of the government's new Three Waters program, and
Yes.
it's something that sort of slipped through without very much attention initially, until such time as the actual legislation was drafted, which was passed overnight, one night at 11 o'clock in the evening. And everybody woke up the next morning to find that if you have a water bore on your property, you now have some significant problems.
Well, that's great news, because I do have one of those that actually does supply
well,
someone else.
Yes, well, many people are waking up to that fact, Commissioner.
Yeah. Fortunately, there's only one other property.
Yes.
But yes, that is going to cause all sorts of angst. I can
Yes, so that's the reason, and I apologise, that's the reason why we've created that little allotment.
Okay.
But again, I do not believe that the existence of that causes any issue as far as jurisdiction, because it's not allotment for intended that anybody can live on. It's only 30 square metres, and the reason it's in that location is that is where the water source is.
So is that the current water source for the existing homestead as well? Yeah.
It is.
Yeah.
Well, sorry, that is an upgraded water source since the issues that Mr. Neve had a discussion with the former submitter about, that who was concerned about.
I saw that.
Okay. So that's not the one they were complaining about then.
No, it's been upgraded since that time.
Okay. And so will they have access to that?
Yes, they will.
Yes, they will. Yeah. Thank you very much. Do you have any further questions on?
No, just going to add there that we're thinking of asking the engineering witnesses later on about that, because there were various allegations raised in that former submission about water quality and such like. So obviously, if there's going to be something that's going to be undertaken, we assume there's been approval by Otago Regional Council and such like, and that the council was satisfied that the supply would be adequate for the subdivision.
Yes, for Mr. McCartney will be able to deal with those issues.
Okay.
I would be. I'm a bit concerned, I guess is the word, about the fact that we are delving into issues that were the subject of submissions which have been withdrawn, and which, furthermore, were the subject of informal discussions between Mr. Neve and that submitter. When Mr. Neve, as I understand it, went on site, he was approached by that person to raise these issues. That person entered into the purchase of the homestead in the full knowledge and voluntarily, on the basis that she was aware that there was going to be further development undertaken on the site, and that she signed a no objection covenant. I think it's grossly unfair that she, having breached that covenant and was reminded about that, and hence she removed her submission, that her grounds of submission are still being considered. Saying that, I fully accept that, given that that party has not given an affected party approval, you are entitled to take into consideration effects on that person.
Yeah, exactly. Thank you. Yes, I think, and obviously water access and quality is important. So
absolutely, no, and there are always standard conditions imposed on any subdivision consent, where you cannot give effect to the consent until such time as you can establish that those matters have been resolved. Yes, and we would expect nothing less in relation to this application.
Thank you. Any other questions at this stage? Or shall we hear from the council as to the jurisdictional?
Yeah, well, I think we did, yes.
Yeah, okay. Well, thank you, Mr. Todd. We might just pause you there, and then I'll just ask Mr. Mr. Neve to respond to the jurisdictional issue and where council are sitting on this in terms of your ability to assess the proposed changes.
Thank you, Commissioners. I thought I'd just start by clarifying the extent of the application site. There seems to be some confusion over that boundary adjustment subdivision. So if you don't mind, can I direct you
Yeah.
to section 3.1 in the section 42A report?
Oh, it's you're a bit hard to hear actually. I think there's a little bit of
Like an echoing
an
effect.
echo. Yes.
Sorry, is that better? Can you hear me?
That's better.
Yeah,
Yes,
better.
thank you.
Can I please direct you to section 3.1 in the section 42A report?
Right, 3.1 submission. Yes.
3.1 submission.
Yes, and there's a clean and
So the shaded area was the application site prior to notification, prior to the boundary adjustment.
yes.
You can see the two northernmost lots were the title, and the large southern lot was the one that the roadside platform would be held with. And to see what the application site currently stands as, could you please go to the applicant's evidence?
Yes.
I believe it's page 43.
It's a pre-circulated evidence, isn't it?
Yeah, page 43 of the pre-circulated evidence.
Here we go.
And you should have a copy of the title plan from the boundary adjustment. So the application concerns lots 3 and 4, which are held together.
Right, so, okay, so 3, I see, so that's the Cadrona Road. So lot 2 showing on this plan,
Has been sold, I
that's
believe.
been sold, yes. So that's the piece that's in your report, that's the piece, well, it's a slightly different shape, obviously, but it's roughly that piece that's showing at the bottom of the page.
So it's south
South.
of lot 1, what is now going to be lot 1, if it was approved.
Yes, that's lot 1 in there, isn't it?
Lot 1 being here, yeah.
Okay,
And I think it would be worth clarifying that the proposed lot 5 would still be held with lot 4 on that title plan. So that would make up the balance of our subdivision.
okay, so that's, so on the plan, lot 5 is 21 hectares. So are you saying that lot 4 and lot 4 is in addition to lot 5? So that's part of the farm, obviously, at the moment.
Yeah.
So that effectively the total remaining farmland is going to be around about, what's that, 47 hectares.
Yes, yeah, that's
So I got
right.
that right. Okay, so lot 4.
Plus the pastoral lease.
Plus the obviously, yeah. But the free, so the remaining freehold land will be roughly 47 odd hectares.
So 46.
And it goes around here, doesn't it?
Yes, that's right. That's 26. Where's the other part? 20.
And then this is lot 5, so that's the split. And then it comes around here and goes in front onto the Cadrona Road. It goes onto the road. Yes, that's what it does. Yeah. Okay, I think that's helpful. So that's the entire freehold. I think it'd be quite nice though to still have a plan of the station with the pastoral lease and where the working parts of the station are, and then showing this freehold component of it as well.
That would be helpful. But also be interesting to know if the freehold is tied to the pastoral lease in any way, if they're entirely separate sites. So I feel like it's entirely separate from the application site, despite being used as one farm.
Yes.
Anyway, so unfortunately my initial thoughts are this is potentially beyond scope of the application and notified.
Yes, do you want to elaborate?
So we've moved 2 platforms from the hill down to the plain. Yes, they're still in a similar-ish location, but I believe it is a different application. I agree with Mr. Todd. It's unlikely that he might get many submissions on the application if it was re-notified, but you never quite know what people will submit on, and I still consider effects to be at that threshold that would warrant public notification. And I think the differences are enough that it might be beyond natural justice not to give people a chance to make a submission. And my other key concern, and this is potentially a legal matter, I understand that the submitter who withdrew has a no complaints covenant on their title, but we're still relocating a platform directly adjacent to their boundary, and there's going to be increased usage of that legal road and right of way. So now you've got 3 proposed lots using that right of way and road. And I think that's enough of a change or an effect on that submitter's property that I potentially think you would have to re-notify. I don't see how you can get past the Section 95 test and the applications is different.
So to what to what extent though, if there is a no complaints covenant on that land, to what extent is that, would that property owner be entitled to make a submission anyway? Just if it was re-notified.
Yeah, no, this is you sort of find yourself stuck in a loop, because I understand they can't make a submission, but I'm not sure where you can consider such a matter when determining effects on the process.
We're determining the Section 95 test, yes. That's, well, that, yeah, that's what was going through my head, actually. So you're saying that effectively that the changes are sufficient, that the effects would be such that if it was re-notified, that it may cause more it wouldn't pass the threshold for non-notification, so it would have to be publicly notified, and then there may be submitters who would likely submit because of the changes in effects. Is that what I'm?
It is. That's correct.
Yeah. And what are those changes in effects that you're specifically referring to?
You've relocated 2 platforms down into the plain. So in addition to effects on that submitter's property, they're both closer to that road reserve.
Yes.
You're also now encroaching up the valley, along the valley floor, which can have different levels of landscape effects, I guess,
Yes.
on the ridge line. I just think there's subtle differences here that I can't glaze over.
And I'll come back to Mr. Todd for a reply shortly, but obviously we will adjourn the hearing to consider this, but if we came back and said actually we do believe it's within scope, what is your position on having been able to assess the changes, and in terms of if we proceeded with the hearing today, and would there be any way that we could accommodate that, for example, giving you the opportunity to make your or to present further evidence, or to present your comments in writing?
Yeah, I think we could still proceed with you with the opinion. I've discussed it with Mr. Denny and Mr. Jones, so I think council's opinion is we could work through the assessment.
Okay. Today?
Yes. Yeah. It's just whether or not there might have been submissions that could have added to that assessment. I don't know.
Yeah. Yes.
Now, just thinking aloud, I suppose, but I imagine since this application was initially lodged, There've been quite a lot of changes affecting ONL provisions, which we've become aware of. Some of them very recent with respect to Chapter 21, assessment matters and such like. Yeah, there's certainly, I suppose, if it were re-notified, I mean, hypothetically, a party like Upper Clutha Environmental Society might or might not get involved in an application like this. It's difficult to know, but it seems to me to be very much a legal issue. Have you sought advice from the council's own legal advisors in this respect?
No, we have. Yes.
Is it yes or no?
No, it's not.
No, sorry. I am struggling to hear you about this.
That's fine.
It's all right. It's just, I think it's just a bit echoey at times. All right. Is there anything else you wish to add at this stage before I go back to Mr. Todd?
Not at this stage, no.
Okay, thank you. Mr. Todd, would you like to respond to that? And I think we'll then take a short adjournment to consider the matter.
Yeah, well, first of all, I have to say, Commissioner, this is the first we've heard about this concern. I appreciate you are entitled to raise it, but if the position of the council is that there is a jurisdictional problem, we've never heard that before. Secondly, Mr. Neve notes that, and I'm using his term, it is a subtle difference that has been made in terms of the change, and all he has said is that really the two have gone to the valley floor and closer to the unformed legal road. Given the concerns that were raised by the council in their initial section 42A report about their concerns about the effects of the development being on the terrace escarpment, one would have thought that moving them down off that and behind the existing development and existing vegetation, etc., into what is acknowledged by Mr. Neve in his report, an area of human activity, that would have been a positive change rather than negative. In relation to Mr. Nixon's comment, I think the Upper Clutha Environmental Society's position stands for itself. It hasn't worried about whether matters have changed in terms of the district plan as to whether they submit or not. They normally, if they have a concern, they submit, and they haven't submitted to public notification of this application. In relation to a change about in terms of public notification, I think the issue is not one necessarily for section 95. It's a question of whether or not there is jurisdiction for the change. And it's my submission to you that on the basis of the submissions that I made in my written submissions and what I said to you this morning, that you do have jurisdiction for this change, that the effects are not greater, and it is, in my view, highly unlikely that anybody, given the period that has lapsed between the original application and now, the fact that poles have been erected on the sites of the new, that somebody, if they were going to come out of the woodwork, would have come out of it by now.
All right. Oh, thank you, Mr. Todd. Well, look, I think we will take a short adjournment at this stage. So if we resume at, say, everyone a bit of a break, 10:15. Which is about 20 minutes. I think that would be very helpful for us. So we will consider this matter now and come back to everyone.
Trish, are you there?
Yes, I am.
How do we work the breakout so that I can speak to my people?
Let me, breakout rooms, here we go. Assign. Manually. Who do you want on there, Graham?
BNSB, Kerry Vivian,
Yeah.
George Collier, John McCartney, and Peter Forrest.
Okay.
Thank you.
Hang on, don't say thank you yet. I've done that. Breakout room. But I haven't got you in there.
Oh, sorry, me too. Yeah.
How do I put you in now? Oh. Add.
I presume only you can do this as you're the host.
Yeah, but I and you, yeah. Right, there's 6 people in there. Is anything coming up on the screen? Does anyone who's listening know what to do? Breakout room 1. Can you see anything on your screen, Graham?
No. Whereabouts on your screen are you dealing with it? Oh, here we go. Yep.
What are you seeing now? It's in progress. Okay. Hi, I was just doing a breakout room. They've stopped it now to decide. Okay, and I've just got Juanita making them a cup of tea, so she's stress city. Graham, have you finished in the breakaway room?
Yes, we have, thanks.
Okay.
That worked very well. Thanks, Trish.
That was a fluke.
You'll have to teach me how to do that because it's quite useful to have.
Well, just press a whole lot of buttons and something will happen eventually, and panic because you're home alone and you haven't got your young people to help you.
Yeah, that's right. The young people's
Yeah.
the secret.
It is.
All right, are we back on air? Great, thank you. I'll just, I think we're just missing the council staff at the moment. No, we have the council staff.
Yeah, we see it.
And Mr. Eastby and Miss Anderson.
On here.
Oh, sorry, Trish, yes, I meant the applicant, sorry. Confusing both Miss Andersons.
Yeah, I think it's only just turned 10:13. So
Yes, it has. We're a little early. We'll wait for them to come back.
thanks.
All right. I think we're all back now. So we'll resume the hearing. So thank you very much for your patience. We have considered the matter, and in short, we are, I think, persuaded by Mr. Todd's arguments set out at paragraph 23 of the submissions. I mean, the test here is whether there may have been someone who would have made a submission that would not have made it on the original application. And although the effects, obviously the layout of two lots has changed and they've been repositioned, the effects are different, but in essence similar, and probably no greater magnitude than those that were originally notified. I think in the context of that, re-notification would probably not be fair to the applicant in this case. I think it's highly likely that because of the elapse of time between when this was first notified in 2018 and 4 years later, and the fact that we are in a different planning environment may possibly elicit some submissions, but that's actually not the test that we are facing into as far as the scope decision is concerned. So we sort of agree with council that it may well be more submissions, but that's not the test that we're in, because it would be for a different reason. It's not because of the effects of the actual application. So I hope that will make sense. And Mr. Neve, thank you for your thoughts. And we are, I guess, you have advised that you are happy to work through the changes in terms of the assessment today. And I think when we get to that stage, if we do, depending on the evidence that's presented this morning, we would certainly be minded to grant time for you to put either, well, we may ask for further evidence, or we may, you know, we'll just see when we get to that position if it appears to us that we need to give some directions around how we proceed. So we'll just leave it and see how it goes. But so that's all right. We will now continue the hearing. So thank you, Mr. Todd. We'll return to your submissions. So I think we can, we have read through them. We've dealt, I think, with the boundary issues. So if you would just like to take us through the rest of your submissions, just you don't have to read them if you don't wish to, just comment on anything you'd like to draw to our attention, and then we can ask a few questions at the end.
Thank you. I guess really a lot of the background was to the submissions was laying out the basis of the changes, the jurisdiction, and I believe that the planners have properly identified the relevant objectives and policy framework against which you need to consider the application. And the key is, the real key to it is the new policy that has come about via the Environment Court's decisions arising out of appeals on submissions to the proposed district plan. And in relation to the ONLs, the issue that you have already raised this morning in terms of the key policy being 6.3.3.1, and the fact that that policy in itself does not seek to impose any prohibition on development in the ONLs, of course, because it remains a discretionary activity, but it does tighten or raise the bar in terms of development. And the two issues are that landscape values are to be protected, and secondly, that all changes to the landform or other physical changes to the appearance of the land, which is interesting in itself, as I raise, given the permitted baseline as to what you can do with land, will be reasonably difficult to see from beyond the boundary of the site in question. Now, again, having discussed this with other council and planners, this is an interesting new test because it's not a question of being on the boundary, it's a question of beyond the boundary, and it's not a question of it being invisible, it's an issue of being reasonably difficult to see. And so that becomes a subjective issue.
Yeah.
And I'm dealing with the second qualifier first here, because if it's reasonably difficult to see, is it deemed to be reasonably difficult because, as is our view in this case, for example, on the unformed legal road, there's two issues. Is the unformed legal road a boundary of the site, or, which I think in this particular case it has to be, because we have a freehold title, which is one site, and then we have a pastoral lease, which is a second site in terms of the definition of sites. So, but if those parcels, for example, were amalgamated or both freehold parcels, would we be arguing about whether or not it was reasonably difficult to see from the unformed legal road, which is not a boundary of the site in the normal sense, it is a dissection of the site, a legal road or an unformed legal road, you can have a site on both sides of that road. Mm-hmm. Now, the second interesting argument that rises here is, what if, and it would be relatively easy in this case, for us to arrange for the leasehold owner of the neighbouring site to give their affected party approval. Now, we have a test which says reasonably difficult to see from beyond the boundary of the site, but then we have an argument that if we provide an affected party approval, you're not allowed to take into consideration the effects in respect of that person who has given that approval. And there is an extension of that test, and it's probably relevant for the pastoral lease, given that pastoral leases have carry with them the right of exclusive possession. And therefore, somebody who's giving an affected party approval, it's only those people that may be invited onto the site who haven't given the affected party approval who you could take into consideration their concerns. Now, so we have this situation with this new policy where we're effectively conflating two tests. One is that there's a policy saying that the changes must be reasonably difficult to see from beyond the boundary, but we're almost talking about an artificial person, because in terms of who might see from beyond the boundary, because if somebody gives their affected party approval, as I come back, you're not allowed to take that into consideration. So therefore, that brings me to an issue of what happens in a case where it's a discretionary activity, where we're effectively asked under section 104 to consider whether a proposal is contrary to the policy objectives and policies of a plan. Now, is it contrary when you have this policy, when you might have an affected party approval filed by the neighbour, and that person says, well, I'm not affected, and you can't take them into consideration when they're affected. So therefore, are we talking about in respect of that neighbour, the policy being contrary? Now, I acknowledge that in this particular case, you also have people who may be on the road, who may be on the other side of the road, who may be on the road up to the snow farm, who might see it from a distance, or indeed you might have the next door neighbour who has not given their affected party approval, which I've acknowledged, and therefore you are entitled to take into consideration the effects from that property and whether or not the development that will be facilitated by this, any consent that is granted, remembering we're not actually applying here for any development. We're only applying for a subdivision. And that's another issue that makes this policy difficult to interpret, because it anticipates that we're talking about applications for consent for development, whereas in this case we're applying for an application for a consent for a subdivision, which might, if it is given effect to, it will result in development, but the development is not the subject to this application. And development on these blocks within any approved residential building platform is a controlled activity. So we've got all sorts of difficulties with the second qualifier that I see. At the very best, you can look at it from beyond the boundary of the site, and in the context of this application, that would mean and the Cadrona Valley Farm site, of course, who haven't given their affected party approval, but they might, they may, or they will see the building platform on lot 1 and subsequent development on lot 1. So we've got the issue of beyond the site. We've got the issue of there is no development application here. We've got a third issue that the policy seems to contemplate a test as to whether it's reasonably difficult to see what might be a permitted activity, namely the planting, because that changes the appearance of the land. And then we have the subjective test as what is reasonably difficult to see. So there's a real issue here with which, and I'm not aware, and I've checked, and that's why my discussions with other parties, as to whether this issue has actually been debated in the context of any other application, and I can't find any examples of where it has. The second issue, and I'm happy to stop there and discuss that issue.
Yeah, shall we do that? Because this is really interesting. Because I mean, normally I think you point about the subdivision. I mean, I suppose under the ODP, the way that the framework worked was that you would generally have applied for a subdivision and land use consent, which would actually then give effectively consent for the development. And so,
but not always.
Not always, no.
You often just have an application for a subdivision with an approved residential building platform. The consequence of approval of that application means that any future development is a controlled activity where you wouldn't necessarily be looking at this policy.
But wouldn't, though, if the subdivision gave rise to an approved building platform, and as you rightly say, that would then be a controlled activity, wouldn't that then qualify as development?
Yes, it would, but it doesn't qualify. The subsequent application would certainly qualify it as a development. But look at the wording of the policy. The wording says,
I'll just grab that actually. So we're looking at
3.3.1,
yeah.
and it's on paragraph 52 of my submissions. The wording, and if we can take you through it carefully, the qualifier says all buildings and other structures.
Yes.
And we've got neither in this case, in this application.
Yeah.
And all changes to landform or other physical changes to the appearance of land will be reasonably difficult to see from beyond the boundary of the site in question. In my mind, if you're considering that policy, then you are only entitled to consider, at best, the earthworks and the landscaping that is proposed as part of this application. And then you have to consider those in the context of them being reasonably difficult to see from beyond the boundary of the subject site. And that then brings into the fact that you've got existing vegetation on certain boundaries of the site. For example, quite extensive existing vegetation along the southern boundary of Lot 1, adjacent to the road.
Yes.
And then you've got other vegetation around and beyond the boundaries of the existing homestead, some within it, and that's not within our control. So I don't think we can rely on that. But it doesn't say we can't. The policy doesn't say. It just says, will the changes be reasonably difficult to see?
So my understanding here to say that you're looking at a subdivision, and effectively subdivision means pegs in the ground and a line on a piece of paper. And because you can't see that, you can't take into account the likelihood of a subsequent building being put on there.
Well, I don't think that was the intended outcome, Commissioner.
No.
I'm sure it wasn't.
And I acknowledge that. But this is a change that has come about from a change from the ODP, because we didn't have this in the ODP. We had it in the Wakatipu Basin. But again, in terms of the reasonably difficult to see test, I don't think it's ever been actually tested, because the wording isn't the same in the ODP, if I recall, for the Wakatipu Basin. I think it said something along the lines, will subsequent development be reasonably difficult to see? Here it specifically says all buildings and other structures and all changes to landform or other physical changes. Yet this is a policy which I acknowledge relates to subdivision. So it's quite unusual that those riders are included and the consequence of them, or that qualifier.
I suppose the question is whether subdivision and as part of that process, the establishment of the building platforms, which is part of the subdivision, could be taken to infer or imply that there will be subsequent development on that site. So inherently, development is I guess to some extent subsumed within the definition of subdivision. Is there?
Well, I would normally, and look, I think the intent, that's what it was intending, because this is a policy which relates to subdivision. But what I'm saying is that is totally dependent upon a second application being made. And that is the application for the right to build. Because one doesn't immediately follow the other. You're still required to go through a second application. And in going through that second application, it's my submission to you that you could, via things like the design, the colors, the materials, the location is already set, but the design, the colors, materials, you could make a development reasonably difficult to see. Whereas, especially where you're looking at it from beyond the boundaries of a large site. I'll give you an example. Let's say we're looking at, in the Wakatipu Basin, a development on the faces above Lake Hayes, and we're looking at it from the walking track on the western side of Lake Hayes.
Yes.
Northwestern side of Lake Hayes. You're looking across Lake Hayes at quite a distance, and you might be able to make, and I have been involved in cases where you've been able to, via design and other changes to the landform, which are not immediately obvious, you've been able to make the development reasonably difficult to see. So I can understand where they're coming from, and I can understand that this policy will be taken into consideration when you do come to making an application for, albeit a controlled activity. Can't be declined, but the council could still say, you are required to make this development reasonably difficult to see. But can you do that in terms of the wording at the stage of subdivision? It's my submission strictly on the wording of the policy, you can't. And therefore, if you can't, you are not you cannot be deemed to be contrary to the policy. Now,
very interesting argument. Yeah.
Now that's the second qualifier. The first qualifier also causes us difficulties because the Environment Court itself has said to the council, okay, we're going to ensure that landscape values are protected, and we're going to insert a policy into the district plan to make sure, and they've done that. Yet at the same time, they've turned around and said, well, we're not actually sure what are the values of various landscapes that are appreciated. So we want you to go out and do some consultation with the community and ascertain what those values are.
And those are the priority areas, aren't they?
That's correct. And that is exactly what the full council resolved at their last meeting to do. And one of those areas is the Cardrona Valley ONL.
Yes.
So as at this moment, we do not actually know what the community's values are in terms of that landscape. Now, we have got some understanding from prior decisions what the court considers the values are, or and that is a reflection, I guess, when a court makes a judgment, they are reflecting to some extent the community's values. But the court has actually specifically ordered the council to go out and consult with the community and ask them what are the values that they have in particular priority areas and landscapes. And they're about to do that, as I understand, next week. The notification will go out, and they've extended the notification period because this will be quite a major exercise, given the number of areas that the court has asked or directed the council to consult on. So unfortunately for yourself, hearing this application today, we've now got to ascertain what are the landscape values, and does the application for a subdivision, which may have the result, I'll go further, is likely to have the result of dwellings being placed within these building platforms. I think that's a fair acknowledgement. That what are the values, does that development protect the values of the Cardrona ONL? And I think that's where Mr. Espy's evidence becomes very important, because what he does is he looks at the Cardrona ONL and considers what is the context of different parts of that ONL, namely south and north, and then of south and north of the valley, and then goes further and says, well, actually, if you look at the valley, there is these nodes of human activity that are located all the way down the valley, in different scales, admittedly, at the mouth of those valleys as they adjoin the Cardrona Valley Road. And there's Rob Rosa, the spot, we've all driven up and down the valley. We know where these are. Spots Creek, Tui Valley, just past. And then there's different scales of human activity which exist and are more prevalent in the northern part of the valley than they are in the southern part of the valley, because in the southern part of the valley, the properties are dominated by pastoral leases, and you don't tend to see any signs of human activity other than users of the very busy road. You don't see any signs of human activity from the summit almost until you get to Cardrona, the township itself. Whereas from the Cardrona township towards Wanaka, it's a lot more prevalent. There's a lot more activity, as both Mr. Vivian and Mr. Espy have identified in their evidence, and they've spelt it out for you. I don't need to repeat exactly what it is. So to the extent of this exercise about values, it's my submission based on that evidence that it could be argued that there is a higher value appreciated in the southern portion of the valley than maybe necessarily in the northern portion. If you look at it on, as I think we always have to, and I've argued this numerous times before commissioners and the court, when you're talking about an ONL, you're talking about a spectrum of the ONL, from one end where it's extremely remote, almost national park type status, to other areas of the ONL. For example, the Wanaka foreshore is an ONL. And that is a very busy place with lots of human activity, people on the beach, boating, all of those types of things. But you have the spectrum of the ONL. And that argument was accepted in the Wanaka water sports case, where they said, where the court found, notwithstanding it was an ONL, the court found that it was at the lowest, the edge of that spectrum. The Wanaka foreshore ONL was totally different to a very remote ONL on the other end of Lake Wanaka.
I'm very familiar with that case, Mr. Todd.
Yes.
Were you the commissioner on
Yeah.
it? Right.
Yeah. So, yeah, so when you're assessing the values, I think that's some guidance that this or starting guidance that you can get, and then you may bring your own perceptions and to the argument in terms of what, and of course the difficulty that you have here, you haven't got a submitter in opposition who's saying to you, well, what I value in terms of that landscape is A, B, C. We don't have that here. You do have the assistance of the council staff, in particular Mr. Denny, who will be able to identify what he considers to be some of the values. And I acknowledge that in the exercise that the council have done, they have tried to identify what certain ONLs, what values certain ONLs do have, but that's only a starting point for consultation. And it may well be that after the consultation has been completed, we may have a totally different set of values for different ONLs.
It seems to me it might be similar to the LCU system in the Wakatipu Basin. Maybe a series of descriptors for the Cadrona Valley, a set of descriptors for Wanaka West and such.
Yes, I don't know if you've actually seen the council's work that they've done to date, but it's public information, and it was submitted to the, and I can submit to you what they have come up with for the Cadrona Valley to date. But that's only, as I say, that's only the council's staff and consultants' view in relation to those. They are now required to go out and consult. And yes, you're right, Commissioner, that I would anticipate that as part of this process, those descriptors could change quite dramatically, because the community might say, well, and there may be a scale of values as well, that they may value certain ONLs significantly more. And of course, the community has done that in the past, because they've, with the Wakatipu Basin, they have said that those values, there needs to be a higher level of protection than for the district wide. So, you know, where this all ends up, I'm not sure. And that doesn't make it easy for you interpreting what the policy, whether or not this proposal is contrary to what appears to be the key, on first glance, the key value, policy that we should be taking into consideration.
So that's really helpful, Mr. Todd, and it would be helpful if you could just point us to that work that has been done on.
Yes, I'll find that for you and get that to you.
Yeah, I haven't seen that, so that would be very helpful. Yeah.
And I presume you only want the one for the Cadrona Valley.
Yes. Yeah. Yes. Yeah. But I think this is certainly one of the key, if not the key issue in this particular application. So it's really helpful. Any other questions?
So really, I don't know if there's anything further that in terms of my submissions, because of course I was somewhat hamstrung by the fact that I've yet to hear what the council's position is in relation to the amended application, as you are. So it's probably going to be the more meatier stuff will come in the reply.
Exactly, and yes, and as I said, we can make directions around that so that we all have sufficient time to understand what those and what that evidence is. So that's very helpful. Have you got any questions of Mr. Todd?
Yeah, just going back to your initial point and about the legal road and who might be affected from viewing the site from the legal road. I think it's fairly obvious to all of us that the three sites that are facing the legal road would be obviously visible if the legal road was being used by people. I think that's fairly clear. In terms of the land to the north, which is leased by the applicant, presumably they give themselves, effectively, they can give themselves consent basically to, yes. And that would eliminate that problem. Would it be correct for us in terms of looking at the legal road? I'm not sure whether the Act still has the words reasonably foreseeable, and I think it got raised in a couple of the reports that, if no one walks up there or uses it to any great extent, perhaps at some indeterminate stage in the future, Cadrona ski field might like to use that as an access route or something of that nature. But would be fair to say that's getting so much into the realms of speculation that we could probably conclude that it's not reasonably foreseeable that this road will become a public thoroughfare.
Yeah, I think that is fair. We're certainly not aware of any plans, and the applicant's not aware of any plans or any discussion by the council for it ever to be opened. I'd be very surprised if the ski field would want to use it, given the significant investment that they have in terms of legal roads and their and of course there's also it's public knowledge that there has been plans to put a gondola from the new Cadrona village development up to the ski field. So whether or not that would ever be open for that reason, it's more likely to be opened as part of some form of public access. But as to my understanding, and again, Ms. Anderson, if you come to ask her the same question, I don't think it leads to anywhere of any great consequence.
That was my next question. Yeah.
It's not just dock
where does it go?
No, and given the propensity for this community to have tracks, we're very lucky. We seem to have tracks everywhere, walking tracks, and indeed in the Cadrona, there's a track up through Spots Creek, a public track. There's a public track on, I'm just trying to think of the station right at Cadrona itself, but you often see vehicles parked on the side of the road. There are stiles, there are dock signage, all of those things. And so, if this was a priority area, and the evidence from my discussions with Miss Anderson is that she has no history of anybody using this track that she's aware of. Now, I appreciate modern times, GPS systems, people can find things that they may not previously have known even existed unless they've looked at maps. But yeah, there's no evidence of it being reasonably likely that this is going to be opened.
Yeah, no, well, we could possibly ask Miss Anderson about the track and where it goes, and obviously there is no evidence of anyone actually using it, but just in terms of, and I suppose I'm quite interested in what other public access there might be on the station full stop. Are there any other tracks or anything like that, or is there likely to be any?
Yep.
All right. Well, that's any other questions?
No, I have no.
I just have one, Mr. Toyland, just in relation to your paragraph 30. We talk about the purpose of part 21.2 and the sustainability of pastoral farming.
Oh, yes.
Do you want to just talk about that? But also, I recall that this has been raised and dealt with or commented in potentially by the court in some of the Mackenzie country cases. I'm not sure whether you're aware of those, but and whether you can point us to, if they are relevant, whether I think Judge Jackson did have some comments around, I guess, this kind of argument, and how we should consider this.
Well, you're very lucky. Yeah. You're very lucky because Mr. Vivian is here, and he is very familiar with the policy framework in the Mackenzie, and in particular the latest, or not the latest, but a plan change in the last few years where this issue did come up, and where basically Judge Jackson said that opportunities should be given for nodes of development within these large stations, because in a recognition of the fact that if as I recall, and Mr. Vivian will correct me if I'm wrong, that the community was expecting pastoral farmers to maintain these large swathes of pastoral areas, and that there should be some recognition of the ability to have some limited development. And I forget the exact term that found its way into the district plan, but again, Mr. Vivian will tell you all about that. But I found it interesting that the district plan does have this introduction, our district plan and the PDP, because it's talking about the long-term sustainability of pastoral farming. And of course, that's something which has been in the news in our district over the last 10 or 15 years, because it's become increasingly difficult for young people to get into farming, whether that's by way of succession, family succession or otherwise, simply because of the values of these blocks of land, and whether or not pastoral farming can remain sustainable, or are they going to be purchased by overseas people and locked up, or in some cases made available to the public via, in the case of the Motu Tapu scenario, but it talks about being able to achieve economic returns from using the natural and physical resources of their properties. Well, one of those natural and physical resources is the fact that these are very desirable areas where people want to live, and that is part of the resource. And so therefore it's important to acknowledge the potential for a range of alternative uses for rural properties that utilize the qualities that make them so valuable. It's almost being written as a real estate ad, with respect. But I'm sure there's other uses, recreational uses, all sorts of uses. But what it is pointing to, I think, is that a recognition. And many years ago, we used to have a provision in the district plan, for example, where retiring farmers could subdivide off a block for their own occupation. We don't have that. This is a much more general statement. But and again, Ms. Anderson, there are some sensitivities around the issue, but Ms. Anderson will be able to answer questions about her ability to get into the farming by way of succession. And to do that, it may mean you have to sell off what is very small parts of a very large farming operation to enable you to fund your way into that. Mr. Collier, who has a lot of experience in terms of farm succession, both in his role as a farm advisor and one of the leading agri accountants in New Zealand, recently recognised by a fellowship that he received from the Chartered Accountants Society, he will tell you that this is a very difficult balancing act in terms of looking at a site and saying, well, is there some potential to subdivide off a part, either in terms of minimal area in the overall scheme of things, or more importantly, and what we anticipated is going to become more important in terms of the soil qualities, and that's why I've asked him to produce the additional information about the soils that are being sacrificed here, because that is going to come to the forefront with the new national policy statement on versatile soils. And that's why I've asked him to consider that, because I thought that might have been a question that you had of him. But it is an important recognition, I think, for the district to have this, the purpose of the rural zone, that part of the purpose of the rural zone identified.
Yes, thank you. That's really helpful.
Yeah.
Well, thank you very much, Mr. Todd. No further questions. We might just take a quick 5-minute adjournment for a comfort stop if anyone needs one, and resume in 5 minutes. And I think it would be helpful just to hear from Mr. Anderson about the background to the subdivision, and also those questions we had around the unformed legal road.
Well, maybe what I'll do is I'll just lead her on a couple of matters before the other witnesses, because the answers that she might give may open up some other questions for those other witnesses.
Okay, that would be helpful. Right, thank you. We'll be back in 5 minutes. Thank you.
Thank you. Ben, can you ring me on my cell phone, please?
vegetation to trash.
All right, I think we're all back, so let's, thank you. So Mr. Todd,
Yes,
back to you, please.
thank you, Madam Chair. And Mr. Espy has unmuted himself, and he has with him Ms. Anderson, who effectively is the applicant in respect to this matter. Ms. Anderson, you've heard the discussion that we've had around the introduction to the rural provisions of the Act. Could you just explain, for the benefit of the commissioners, what is happening in terms of your farm succession and where that's at?
Right, so the farm is currently held in a family trust, of which my parents are the main shareholders, and I have 2 sisters and 4 children that are all beneficiaries of that trust once the parents are not here. Myself and my husband have been on the farm for probably the last 35 years, since we both left school. So that means that we have been farming a large pastoral lease that has a value currently in the tens of millions of dollars, and have been on a low wage. So that means that we probably can't necessarily buy it off of our parents. And I have 2 sisters that are likely to expect some form of payout from that, and I've got, as I said, 4 children, and at least 2 of those are interested in coming onto the farm. So to be able to pass the farm down to the next generation is the biggest priority for our family. And with the current values and the way things are, it's quite a difficult process to go through. So what we looked at doing was what was the piece of the farm that was the most important to us, what was the piece that was the most valuable and would stay as a farming entity, and then what parts of the farm were least valuable as a farming entity and would be of some use to somebody else. And this area where my grandmother used to live was a piece of the farm that wasn't really utilised. It's only really been running rams and some cull stock, so the hill face there is not very productive, as you will have seen. It's got quite a lot of gorse and stuff growing on it currently, so it's not well used, and it seemed a logical place to look at subdividing when we started this process about 5 years ago. Yeah, that's the point of being more than one subdivision piece coming up and having 4 was to hopefully safeguard that, so that we wouldn't need to do this again, and we would have enough of an income that the next generation could just carry on farming and not have to think about how they were going to pay out the rest of their siblings or however.
All right, thank you. And could you just comment about the issue about the unformed legal road? From our discussions, you mentioned to me that you're not aware of usage of that road, and where that road or alignment of the unformed legal road eventually ends up. So
the unformed legal road is it divides the freehold from the pastoral lease, and it goes basically right around the outside edge of the freehold, and I think that it doesn't quite touch the Skifield Road, but it may just touch the Skifield Road, which is private road anyway. But that's as far as it goes. It doesn't go to anywhere other than through our paddocks. And it's been, the freehold and the pastoral lease have been run together since the early 1920s, when my great grandfather bought the freehold and added it to the pastoral lease, and to my knowledge nobody's ever used it other than ourselves. There's never been anybody asked permission or been anybody up there, and it literally runs through irrigated pastures, so there's no actual formed road where the legal road is. There's not even a farm track on most of it's just pasture.
Right.
Thank you. Could you just answer any questions from the commissioners, please?
Thank you, and thank you very much, Ms. Anderson. That's really helpful. So, so just with the unformed legal road, so actually I can see now on the plan that Mr. Neve referred us to on page 43 of the evidence that it actually does go around the freehold and then just head off in that direction. So that's really helpful. So when you say, so your great-grandfather purchased the freehold, so has that always been just a sort of random freehold block? Because I imagine it's sort of sandwiched between.
Yeah, as far as I know, it was surveyed in 1880 and was held in a block of 5 titles, which we subdivided some of that and did it, well, didn't subdivide, we did a boundary adjustment with Cadrona Valley Farms, and they added some of that to their property. That's only just been finalised, but it was done in 2018.
Right.
But before that, it was always just run as part of the pastoral lease.
Right. So it's always been just effectively part of that. And I guess my other question was that just in terms of the farming operation, so obviously the house that you've answered my question about the existing house that's actually no longer part of the property. So that was just it was never the headquarters for the farm then, or was it just a house on the property?
No, so when my great-grandfather owned the property, there was no house on the freehold, and the main hub of the farm is where it still is now, on the pastoral lease.
Yes.
So all the cattle yards, wool shed and the main homestead are on the pastoral lease.
Yes.
When my grandfather and my grandmother were there, they had lived in the house on the freehold because all of the freehold was controlled flood, and it was my grandfather's job. His main job over summer was doing that, so he was up every 2 hours in the night. It was much more productive for him to live closer to it than to be on the pastoral lease, so they had a house there.
Right.
And my parents moved into the main homestead on the pastoral lease.
Right. Okay. That makes sense.
Okay, just to clarify for me there, so the main homestead, is that in the next valley to the north, or trying to figure out where it is? Where is that?
Yeah, so it's on the pastoral lease, and it's up the Branch Creek
This
valley.
is like the next valley up, isn't it? Or next valley down towards
Yes,
one.
yes.
Yeah.
And it's about, the main homestead is about 3 kilometres from the main road, and then there's a smaller house down near the entrance of, like, at the base of the valley, same as every other valley in the.
Yes.
Okay.
Very
Yes. So just one final question. I understand that from what you've been saying is that people don't try and use, because some people around the country are very proprietorial about what they call Queen's chains and legal roads and that kind of thing. But if I understand you correctly, people don't seek to use the legal road to go hunting or tramping up onto the top of the range or any of that sort of thing.
No.
Yeah.
No, they don't.
And Ms. Anderson, so as far as the pastoral lease is concerned, is there any public access or walking tracks or anything on that land?
There's no tracks as such. There's a Queen's chain, or what are they? Yeah, they do have a legal right to go up the main river, but I've never actually seen anybody using that either.
Right.
Yeah, there's no other formed legal accesses though.
Right.
It's a branch room.
Thank you.
I'm sorry, there was just one final question. It may have been addressed earlier, but is the pastoral lease subject to tenure review?
No.
Lovely. Thank you very much, Ms. Enns. That's really helpful.
And Commissioner, in relation to your last question, you'll be aware that tenure review has now closed.
Is
There are
that
no-
how
I'm aware of that,
Yeah.
Yes, thank you. All right, I'll call Mr. Forrest now to answer any questions in relation. Mr. Forrest, if you could unmute yourself, thank you.
Yep.
Your name's Peter Forrest and you are a geotechnical engineer. You've prepared a formal brief of evidence in support of this application. do you confirm that evidence is true and correct?
I do,
And could you just please answer any questions from the commissioners?
of course.
Thank you, Mr. Forrest. And look, we have read your evidence, although actually, and I have to confess in my case, it was a few weeks ago now. I suppose my question, is there anything that you would, any concerns that you would have of a geotechnical, regarding geotechnical matters in relation to this application? And have you assessed the locations of the new proposed lots? And do you have any comments on those? So that's probably what I'm interested in hearing about.
Cool. I undertook a intrusive site investigation at the request of Mr. Vivian from Vivian and SB. The investigation was undertaken due to 3 of those lots being relocated or repositioned, i.e. lots 3, 4 and 5, with the removal of lot number, right?
Yes, they've changed around a bit.
Yeah, that's right. So my investigations were on the current layout with the lots 3, 4 and 5 on the lower terrace.
Right.
So I can confirm I've been to site and I've cited these locations. Geotechnically, I have very few reservations other than lots 3, 4 and 5, as stated in my report, should have what we call a TC2 foundation. This is a somewhat conservative approach to potential liquefaction, but by assigning a TC2 foundation in a Schedule 2A, it's a cheaper and easier solution than actually investigating to prove whether that ground will liquefy or not. And it's quite a common practice to adopt a TC2 foundation. And in practice, a TC2 foundation is, in terms of financial commitment, is not very much greater than a standard traditional foundation in any case. And that is my only geotechnical reservation.
Right. Okay, thank you. And that you highlighted that in your evidence, which I've now just found. So thank you. That was actually, I did have that highlighted as a question just so that I could understand what that actually meant. So, thank you. Any questions?
I just one. I understand that the proposal narrows for a dwelling on lot 2, and that's under the new proposal, which is where the dwelling would have been under lot 4 on the old one. It's the sort of, I think the words we're using is going to be dug into the slope.
Yes.
So I take it there are no issues raised by doing that?
No, that slope is pretty stable. It's been there for some time. There was no evidence of any erosion or rilling or slope instability. The ground conditions were extremely good, very hard ground. And again, with modern lightweight building and traditional foundations, I don't foresee any issues with slope stability. If somebody took it upon themselves to change the building platform location and move it towards the slope, then I'm sure that would be picked up by council in any case, in terms of any further investigation or slope stability requirements. But again, from a geotechnical perspective, I think that's very low risk.
Dr. Forrest, it was interesting actually on the site visit yesterday and looking across Boundary Creek, and then you've got sort of the clay cliffs. Can you just tell us a little bit about the geology of that basin, just out of interest? There's pictures around, so what you're saying is that the land, the subject of this application is not that, doesn't obviously have those characteristics.
No. The basin has evolved through, obviously, its original deposition of its parent rock, which was then subject to tectonics and uplift and erosion, and then subsequently glaciation. And as the glaciers have melted and faded away, that produces quaternary processes which are quite active and create a landscape that is quite dynamic at the time of periglacial activity. And that results in the braided streams and river terraces being formed, etc., etc. But as time progresses and moves on, and as those dynamic processes fade away and become less active, so the surrounding geology becomes quite stable. And that's certainly the case with these river terraces, which are 10 to 12 to 24,000 years old in some cases, and they have remained stable over that period of time. It's only when you start to have undercutting from the active river processes, which are distant from these locations and these lots, do you start to see active erosion and instability occurring. In terms of the clay cliffs, they're not actually clay, they're actually silt, and they're a result of wind-blown deposition of the glaciers as they were melting. It's called Lewis, which you may have heard of. It's quite common through Canterbury and North Otago, and obviously down here in the basin where we've had glaciation. Lewis is quite susceptible to erosion from wind and water, and that's why you often see the clay cliffs with the typical kind of formations that you see in erosion patterns. But again, not really an issue on any of these lots.
Right. And so, obviously we are facing into an issue of warming climate and increasing intensity of severe weather events. Do you have any concerns in relation to the building platforms with regard to any activity from, if we were, I think the science is fairly clear now, but as those events increase, I think you mentioned free flow is not an issue.
Over a long period of time, geotechnical conditions within soils and grounds will change, and that's a worldwide issue, not just to this subdivision. But where soils are vulnerable to, say, increased moisture content from increased rainfall, once they're actually built on and protected and suitable stormwater management are put in place, which is part and parcel of modern building, then their susceptibility is very limited in any case. So in the short term, there's no issues with climate change. In the long term, and we're talking 100, 150 years time, then the soil conditions will change, but that would be part and parcel of any investigation at that time in any case.
Right. Thank you very much, Dr. Forrest. That's been very helpful, and no further questions.
Okay, thank you.
Madam Chair, can Mr. Forrest be excused?
He certainly can. Thank you.
Thank you.
Okay. Thank you.
Now call Mr. McCartney.
Thank you. So, Mr. Todd, just after we hear from Mr. McCartney, I might ask Mr. Jones to comment so that we can actually then deal with any engineering issues so that they don't have to sit in unless either of them would wish to. Just conscious of time, everyone's time.
Thank you. Mr. McCartney, your name is John McCartney. You're a civil engineer based in Queenstown. Could you confirm that you have prepared a brief of evidence for this hearing in relation to infrastructure matters, and do you confirm that evidence is true and correct?
I do.
Could you just please answer any questions that commissioners may have?
Sure.
Thank you, Mr. McCartney. Start with you.
Okay. From looking at the material that we've read, there don't appear to be any sort of showstopper type of issues involved. One thing I did want to raise specifically was water supply, and we've had Mr. Todd explained this morning about lot 100. There'll be a community supply which will be held in undivided shares. I don't want to open up the issue of the comments made by the submitter, except to say there was some discussion in that original submission about water quality. So I'm not so much the submitter's view of the water quality, but is there an issue with water quality that you're aware of? I presume ORC has given consent for a bore, have they?
Yes, so the ORC gave consent to drill a bore, and that was subsequently done by South Drill in November last year. You know, that bore on proposed lot 100 was drilled. It's a depth of about 9 meters. They achieved a good flow of water during testing. So it was test pumped for about 8 hours at 50 litres per minute and had a drawdown of less than 1 metre. So that sort of shows that there's a good water resource there. And you know that should provide a good long-term water supply for the properties it services. Now, at the same time as they drilled the bore, they also sent away a water sample for testing for quality purposes, and that water quality test was, you know, it was a pretty good result. There was a couple of determinants in there that indicated it was slightly turbid, which, you know, it's just an indicator that, you know, it's perhaps not quite as clear as it could be. But there was no detrimental effects recognised from that slight lack of clarity. And I would expect that clarity could be restored with some basic filtration and undertaken at the, you know, installed as part of a water supply of any future dwelling. So, you know, as I've covered in my report, with regards to the bore water supply, because it is still from a shallow source, even though it's an underground aquifer, it's relatively shallow in terms of these sort of water supplies. I've recommended that future dwellings include some water treatment to make sure that you know, any short-term contamination of that water does not lead to health problems from users. So, you know, that would involve filtration and UV treatment typically.
Yes, but you mentioned that the depth was 9 metres, which on my previous experience in Canterbury would seem very shallow. In terms of disposal fields, particularly for lots, what would be 2, 3 and 4, are there any particular matters that need to be addressed there, because given the shallow depth of the groundwater?
Yeah, so, you know, there's possibly two aspects to that. You know, the Otago Regional Council will require that any wastewater disposal beds are at least 50 metres away from the bore. And, you know, I've checked with the lot layout, and there is ample room within each of the allotments to be more than 50 metres away from the bore with their disposal fields. And the other aspect is, you know, just making sure that we treat the water, the wastewater, to a good standard prior to discharging it to ground. So, you know, I would recommend that on those lots, the wastewater is treated to a secondary standard. It's not just a standard septic tank. It's actually a small treatment plant that treats the water, both primary sedimentation type treatment and a secondary process such as oxidation or, you know, biological processes to further treat the wastewater prior to disposal of the effluent to land. So basically we're disposing of a higher quality effluent to the land that is less likely to have a detrimental effect on the groundwater. So, you know, we've still got a reasonable separation between the ground surface and the aquifer. And, you know, when that detailed design is done on each of those lots for their wastewater system, they will need to take into account that by the time the effluent has filtered down through the soil layers and reached the aquifer, it should be of a good standard. And there's, you know, the standard procedures that we employ to ensure that happens.
Mr. McCartney, is the existing house on lot 1, is that likely to have any impact on any of this? Because I mean, obviously that's got it's already established with its own waste services.
That I think it's very unlikely to. Like, I guess the reason I hesitate is the land in that vicinity is relatively flat, but in general, the groundwater will be moving, down that small valley and out into the wider Cadrona Valley. So the wastewater disposal system for the existing house is essentially downstream of the water bore. So I would not expect it to have an impact on the bore water supply. And that's certainly, the testing that was done on the bore water supply, at the time the bore was drilled, did not show any problems caused by the existing wastewater system.
And how about farming operations on the balance lot?
Well, again, there's existing farming operations there now,
Yes.
and the testing that was done on that water supply had not shown that they are creating any problems with water now. If those operations intensified, there's a small likelihood we could see an issue, but I would think it was very, very slim chance of that.
So that would presumably only occur if, say, an extremely unlikely event of a dairy conversion type of operation.
That's right. You might see an increase in nitrates or something reaching the groundwater. But, at the moment, nitrates are not an issue in the water.
Just a point of clarification, I think I understood Mr. Todd correctly, but this supply will also serve the old lot 1, which contains the original dwelling. They're part of this system as well.
That's my understanding as well, yes.
Okay.
Thank you, Ms. Barry. Any further water questions? I just have one question just on the traffic. So we obviously now have under the revised plan, we actually have more traffic entering and exiting at the unformed legal road, I suppose, as opposed to the previous entrance. What effect does that have in your view?
So I've assessed both of those entrances, and there is sufficient sight distance from both of them. So I don't believe there's any issues with the distribution of traffic between those two entrances, or the redistribution rather of traffic between those two entrances.
No, I'm comfortable, thanks.
Thank you very much, Ms. McCartney. We have no further questions. So I'll now invite Mr. Jones to ask any questions of clarification that you might have, Mr. Jones, in relation to the engineering, the applicant's pre-circulated evidence and the issues Mr. McCartney's raised this morning.
Yeah, I agree mostly with what Mr. McCartney said. The conditions as they've been drafted were, I guess, must have predated the PDP. So they refer to ODP transport standards and vehicle crossing formations. So probably the biggest implication for me in terms of the redistribution of the traffic between the two accesses is that now the access onto the unformed legal road would need to be formed in accordance with diagram 9 in the PDP transport chapter, which off the top of my head is probably a bit more work than what would have been required under the PDP. But yeah, perfectly manageable. And there are quite a few of the conditions I'd probably change. I don't think it's well, it's probably up to you, I guess, whether we go through those right now or if we do it post-hearing. It's pretty typical that we get the conditions and look at them. The only other thing I had to note for the transport matters was that there should probably be a turning head at the top of the portion of the unformed legal road that's being formed to allow for refuse vehicles to turn around, because these people will be entitled to council refuse collection. Could possibly be done with volcanoes, have to take it down to Cardrona Valley Road, but that's sort of the general practice is turning heads get installed. That was all I had for the transport stuff, really. Little discrepancies in the plans and whatnot that don't really matter too much. You asked about the treatment of wastewater, and Mr. McCartney suggested the use of secondary treatment, which is really good, and that's reflected already in the conditions that have been proposed in the applicant's pre-circulated evidence. The only other thing I had to say was that Geotargo and I think the original Geoconsulting report refer to lot 3, 4, and 5, or the building platforms being located on the floodplain or terrace of Branch Creek, and then immediately turn around and say we don't believe that there is a flooding risk. That might just be a nomenclature sort of way to describe the topography, but it seems extremely strange to me that you describe something as a floodplain and then say we don't believe this area will flood. Again, it's a pretty easy problem to solve from an engineering perspective. You jack up the floor levels and it won't flood, but then there might be a bit of a squeeze because I understand there would be landscaping issues with the heights of the buildings.
Right.
And yeah, that's all I have to say. Happy to take questions.
Okay, thank you, Mr. Jones. That's helpful to raise that, and perhaps Mr. Todd, you could possibly clarify that in your reply, because I know a lot of valleys get talked about as floodplains that actually may not actually pose a flood risk, and some of them do. But I think we did hear from Dr. Forrest that he didn't have any concerns in that respect. So Mr. Jones, so what I'm hearing from you is that there's nothing material that can't be addressed by way of changes to conditions that could be then discussed between council and the applicant.
Yes, that's correct.
Yes. Okay.
Well, Mr. McCartney, I assume you're always muted.
Okay.
No, I'm still here.
Mr. McCartney, I presume the mention's been made by Mr. Jones about PDP, the proposed district plan standards. He's touched on those, but I presume you'd be reasonably familiar with those and how they've changed from the ODP anyway, given your experience in this district.
Yes. And my updated report did cover off, I agree with Mr. Jones there that diagram 9 is the appropriate access for the legal road intersection, and the other access will be a diagram 8.
Right.
So we're in agreement with most of these matters.
I think a lot of it is possibly just that you need to really thoroughly walk through all the conditions, make sure all the stuff lines up, rather than there's stuff in the evidence that isn't reflected in the conditions. I just thought it'd be worth raising those.
Right. We need to do that right now.
No. Conditions.
Yeah. Okay. Well, thank you both very much. It's been very helpful.
Thank you.
You're welcome.
So, Mr. Todd, back to you. Oh, sorry. Mr. McCartney.
Yeah, sorry. I assume I can be excused now also.
Right.
Hey there, Madam Chair.
Yes, we're here.
Can Mr. McCartney be excused?
Yes, he can.
Yes,
Thank you.
Thank you very much. Thank you, Mr. McCartney. Now, hopefully I've got Mr. Collier.
Yes. Yeah.
Good morning, Mr. Collier. Your name is George Collier. You're a chartered accountant based in Alexandra. You also have a background in farm advisory. Can you confirm that you have prepared 2 briefs of evidence in relation to the application dealing with the potential economics of the loss of the land to be subdivided, and in relation to such land, the soil types and the potential impact on, again, farm economics by the loss of those soils?
Yes, I can confirm that. Grant.
Yes. And could you just please answer any questions that the commissioners may have?
Sure.
Thank you. Welcome, Mr. Collier. Now, I have to say, that this was late evidence, wasn't it? That
The second part was, Mum, in terms
yes.
of the soil evidence. The other evidence was pre-circulated.
That's we saw the second. There you go. Yes. Yes, I have read it. There's a problem when you read things too far in advance these days. You actually forget what you read about.
Yes.
All right. So I think actually what would be helpful, Mr. Collier, is if you can just, I mean, we can take your evidence as read, but if you can just talk us through what impact this would have on the farming operation, and in particular, I'm assuming that the balance lot 5 would actually be retired from farming as part of this, or retired from, it's being farmed in conjunction with the station. But also what other uses that balanced land might have, because it's quite a big chunk of land, obviously.
Yeah, certainly more than a rural lifestyle I would want to use.
Yes. Yes, I've written my submission on the basis that lot 5 could be retained in the farming system or could be taken out of the farming system. If it was taken out of the farming system, then it would equate to about 140 stock units out of the 6,000 stock units that are on the property at the moment. So that would equate to about 2.3% of the total stock if lot 5 was taken out. In terms of what the effect of the income would be, that would be about 3% of the total income from the property, which is about a net income, an income, sorry, of around, I think I've got here $6,000. $6,000 out of 450,000 income from the total property. This land is used typically for the cattle part of the operation, and in particular for young trading cattle. So they're not core stock to the farming business. They're not breeding stock. They're not replacement stock. They're actually steer calves that are retained over winter and then sold in the spring. So they're wintered on this country. But if they weren't there, they're not integral to the farming operation in terms of providing breeding stock and that sort of thing. There's some irrigation associated with that area. So there's 8 to 9 hectares of irrigation there, and 8 of that hectares is on lot 5. And there's sort of half to 1 hectare on lot, I'll just pick that up there. Is it lot 3? Yeah, lot 3. Half to 1 hectare on lot 3, and around 8 hectares on lot 5. Now that water is a water right that's owned by Anderson Branch Creek, and that water can be transferred into the pastoral lease for use on the pastoral lease. The most significant part of the productivity on this piece of land that's been subdivided is actually to do with irrigation water. That is the thing that provides the biggest impact in terms of productivity. Not the soil type, but irrigation water in itself. This irrigation water can be transferred to the pastoral lease. It could actually also stay with this land, and I'm just unaware of exactly what would happen with that irrigation water. But it can be taken across Branch Creek, and there's areas of land there that it can be used on the pastoral lease for, so that the use of the water won't be lost if it's not transferred as part of the subdivision.
Okay, so net then what you're saying is that if the irrigation was transferred to the pastoral lease, then that productivity gain would compensate for the productivity loss of the 21 odd hectares of lot 5. Is that?
Well, not completely, because there's a wee bit of dry land there, of course, and the dry land is running about 2 stock units per hectare. So, I mean, underneath all of this, there's still a slight loss in terms of livestock. But generally in that locality, there's just, I mean, in essence, actually, this area is being used as a ram paddock, and there's plenty of areas that can be used on the property for a ram paddock from a sheep perspective. So that, you know, there is a small loss of land that's around, you know, if it's 30 hectares, 2 stock units, it's 60 odd stock units, it's 1% of the property's carrying capacity. But with the water being transferred, able to be transferred, then the balance of that product can be transferred into the pastoral lease.
And so if that water was transferred, what could you do then on lot 5 if the owners of that lot wish to make use, I suppose, some kind of productive use of that land?
Whole host of things, but that land is actually really suited to lucerne production. It's got some, you know, topsoil, the first 200 or 300 millimeters, and under that it's a shingle sandy type loam, but then it goes down to a water table, which will be into the Branch Creek water table. Lucerne roots can go down, you know, 10 or 12 feet, unlike ryegrass, which is like 150 mils. So there's the ability to tap into the natural water table, and so it's really suited to lucerne production if the irrigation water wasn't there. And I'd suggest it's an entirely suitable land use for that area and those soils.
I guess the reason we were sort of questioning this particular view was that lot 5 is rather odd shaped lot is now proposed. The southern half of it's hill slopes. The northern part is sort of the flat lands, and normally, from my very limited farming 101 knowledge, is that the lower river flats are generally the better land, especially in winter, rather than the equivalent areas stuck up on the hillside in the back of the ranges, which is very low productivity. So I think that's the reason why we were asking that question, because under the original proposal, there wasn't going to, lot 5 was not extending out over those flats like it does now, but it's obviously been changed. So our understanding, I hope it's still correct from what Mr. Todd told us earlier this morning, is this is more likely to be a base for any farming operations that would be undertaken on the property, rather than sold off to a lifestyler with, you know, a horse and a pony and that sort of thing.
Yes, and I think that would certainly be the preference of the owner, Commissioner. However, as the Anderson talked about, there are the pressures of family succession. There is the need to you know, provide extra capital, and it is fair to say there is some pressure from the bank in order to facilitate a succession outcome. So yeah, I guess the owner's just leaving their options open. Certainly that'd be the preference at this stage, is to put lot 4, I think, into the balance, lot 5, I should say, into the what is called lot 4 to the, I get mixed up with the direction, towards Cadrona Ski Field. That is one of the options.
Yeah, that's the one to the west.
Yes, so
DP 5120. I think that's the preference, as I understand it, from the owner. But bank pressures, family succession pressures may dictate that that lot 5 actually is sold off at some stage.
right, and so is the land between the road and, so it's still this land remains in lot 5, but between the road and the original building that's now lot 1, is that, what's the productivity of that land? Because I mean, and what would likely happen with that?
Well, that's, I guess, land I was referring to as dry land, and it's really very, very low productivity. It's generally, that wheat piece actually down in front of lot 1 actually has got soils down there. Again, that's basically on the flat down there, but the stuff all through the back country is much poorer soils, and has, you know, it's got a stock between 1 and 2 animals per hectare. That one down the front has actually got reasonable soils, but is, you know, that'd be another good site perhaps for lucerne. What will happen with it? Well, I guess it'll just be farmed as part of lot 1. You know, in the end, it could actually be that the owner or future owners or the current owners actually decides to plant some trees in it. I mean, interestingly enough, carbon farming is worth something in the current environment. So planting trees may or may not form part of what happens with that land going forward. I'm not sure.
Right. Yes, I suppose that, well, certainly there's a lot of debate about that in the sheep and beef sector at the moment in terms of land going into trees. So lots of carbon sinks, I think. Well, I mean, that's a good question. I mean, what kind of trees would be envisaged on this kind of land? Would it be native regeneration? I mean, we are talking about an outstanding natural landscape. I'm not sure about what the rules are around planting other than non-wilding species of exotics.
Yes, and I think there are about you know, there's probably about 30 wilding species that are completely unable to be planted.
Yes.
And, you know, in the end, I guess it comes down to individual owners, but native plantings are certainly eligible for carbon credits. Anything over 1 hectare is eligible as a carbon sink.
Yes.
So in the end, you know what it comes down to? It comes down to trees that survive. So I think you have to be pragmatic about what actually survives in that sort of environment. And the limiting factor of all of that is water. Being able to...
Yeah, exactly.
That's the question we'll be following up with Mr. Espy as well.
Yes.
Yeah. But I think, yeah, some sort of native planting, but there's a wee bit of risk around that because of the moisture side of things, really.
Yeah. Okay. So, yeah. But the irrigation, is that front piece irrigated at the moment?
Sorry?
Is that front piece irrigated?
No, it's not. It's just heavy soil.
Right. I suppose the other big risk is predator control as well, if you're doing anything like that.
Yes.
All right. Any other questions?
No questions.
No further questions. Thank you, Ms. Collier. At this stage, if we do, we'll come back
Thank you.
after the hearing with any further questions once we digest all of this and think about it.
Can we excuse him in the meantime, and then if we need to ask any questions, have him come back in?
Certainly, Mr. Todd.
Thank
That
you.
would be great.
Thank you, Mr. Collier. Now call Mr. Espy.
Yes, I think
How are we
that's-
going for time? Or what's
I think,
your
well, I think it's 10 to 12. We were sort of planning to have a break at 12 for half an hour. Mr. Espy is obviously going to probably be a wee bit longer than that. I think perhaps, and I always find with Zoom hearings or VC hearings, everyone gets quite a lot tired staring at a screen. So I wonder, Mr. Todd, we're sort of making quite good progress. You've got really 2 witnesses still to come, haven't you? So
That's correct.
whether we take a break now and resume at 12:30
Yes.
with Mr. Espy, if that suits everybody. All right. Okay, let's do that then. Thank you, Will.
Thank you.
Thank you. Right, well, good afternoon, everyone. Let's resume the hearing. I think I've got everyone left. I've had a few off the screen. Mr. Todd.
Yes, go ask Mr. Espy to give his evidence.
Thank you. So, Mr. Espy. So
He's well known to everybody, Mum.
Yes, thank you. So we have read your evidence, but we wondered if you could just take us to, or just highlight, I suppose, the key points that you wish to make, and in particular with respect to the changes.
Yeah, certainly.
And there have been quite a few. We were. I mean, if you look at the revised plan on page 168, with the, there's been quite a lot of changes in tutelage areas introducing particular. If you could just talk us through those changes, that would be really helpful.
Yeah, certainly. I thought a good way of doing it. Can you hear me all right?
Yes, we can.
I thought a good way of doing it might be to go through the conclusions section of my evidence, because it sort of hits all the points and the amendments, and I can talk to the plans as well. And then there are a couple of other points that I thought I might helpfully have some comments on that have come up this morning.
Okay, thank you.
So looking at my conclusions there, in summary, the application has been amended in that 2 proposed building platforms have been moved off the more elevated terrace area onto the flat valley floor land. Lot sizes have been reconfigured and amended. Lot 5 is now proposed to be the larger balanced lot, as we've heard. Can
I just clarify? I think it was in Mr. Vivian's evidence, but lot 5 is to be amalgamated with lot 4, isn't it?
Yes,
so,
I think it's currently amalgamated. Yes, and that amalgamation is not to change. So that's right. Lot 5 remains amalgamated with freehold lot 4.
Yes.
The amended structural landscape plan has been prepared that bolsters mitigatory planting, and I can go take you through that in a minute. Consent notice conditions are now proposed that require a vegetation management plan to be submitted and approved that sets out details of existing vegetation to be retained and how succession planting will be done. Additionally, the more exposed escarpment slopes within the site are to be managed to remain in open pasture cover and or native vegetation. Then we've got all of the conditions of consent recommended by Mr. Denny's report have been adopted by the applicant. The above measures have reduced the landscape and visual effects compared to the original proposal. 2 proposed building platforms have been moved to more hidden locations that are part of the existing farm base area. Traditional settlement patterns in the Cadrone Valley generally involve locating nodes of occupation at the mouths of side valleys that adjoin the Cadrone Valley. The current proposal will build on this pattern by intensifying an existing long-established, well-treed node of occupation in an inconspicuous way. In relation to the patterns that make up the landscape character of the Cadrone Valley, I consider that this configuration is logical and appropriate. In relation to visual effects, views into Boundary Creek Valley from Cadrone Valley are particularly fleeting. The scene that is taken in will be altered very little by the amended proposal. The visible part of Boundary Creek Valley will remain largely in its current state. Only one future dwelling will be enabled that sits above the valley floor, and this will be in a considerably hidden location. If parts of a future building are glimpsed, they will be seen as part of a recognisable existing node of occupation that involves visible buildings, including a dwelling. The unformed legal road that follows Boundary Creek is not used currently and does not connect to any public land. A hypothetical observer that walks up this legal road alignment will be able to see built form that eventually results from the proposal. In both the existing and proposed situations, such an observer will be fully aware that they are adjacent to an occupied farm base area. Under the proposed situation, the amount of occupation will be extended up Boundary Creek Valley slightly compared to the existing situation. I do not see that this will amount to any material adverse effects on the amenity of such an observer. In either event, the observer will pass the farm base area and continue up the farm valley. In an overall sense, I consider that the amended proposal will maintain the landscape values and visual amenity of the Cardrona Valley. So, as you've said, it's probably worth going to the amended proposed structural landscape plan briefly. So, a good way to work through it perhaps is just to quickly run through the items on the key of that plan. So, firstly, we've got existing vegetation to be retained, and looking at the plan, that is largely some shelter belt rows of conifers that run perpendicular to Cardrona Valley Road, some rows of poplars that are roughly parallel to Cardrona Valley Road as you move back up the valley, and some areas of conifers and willows around that Lot 1 platform. So that's existing vegetation to be retained.
Yes, so just Mr. Eastby, just while I think of it, so those conifers, the poplars, they are, I think we're fair to say, relied on quite heavily for mitigation. They look to be incredibly mature. What is the health and prognosis of those conifers? Sorry, poplars.
Of the poplars? Well, some are and some aren't. Looking at the plan, the row of poplars that's closest to Cardrona Valley Road, they're quite significantly mature, that's right. Yes. The row of poplars that is on the southern boundary of Lot 4, if you like.
Yes.
That row is not overly mature. They're certainly, beyond juvenile. They're full height almost, but they're not particularly mature.
Okay.
And same with some of the other poplars. Well, there's another bunch of poplars over on the south-western boundary of Lot 4, if you like. They're quite mature as well. So part of the thinking of the amended proposal is to require this vegetation management plan. And I might come to that in a second, but that is to do with successional planting that gets done to replace trees as they become mature. But also on this plan, moving on down to proposed vegetation, we've got the areas of proposed native vegetation, which are marked there, and they have a square metre area given on each of them. Those are to be mixed native shrubs at 1.5 metre spacings. So those are broad areas of mixed native shrubs that will provide screening, evergreen screening, but they also really provide a bit of privacy between the individual building platforms. Then we also have proposed, on the key there, proposed poplars, which are Lombardy poplars. And so there are proposed Lombardy poplars in and around the evergreens. And they really will bolster the existing poplars in providing ongoing autumn colour and that upright form. Lombardy poplars of this sort are common in these nodes of development through the Cardrona Valley at these various side valley mouth nodes of development. There's often, and historically always has been, Lombardy poplars. So there's more of those proposed, and they give this upright form and they give autumn colour. Also proposed there is Cupressus Lelandii, which is an evergreen shelter belt tree that can be trimmed to shelter belts. And so there's most significantly, there's a belt of those proposed on the southern boundary of Lot 4, but they're also proposed to bolster the existing areas of conifers. While we're there, if we come down to the proposed curtilage areas, individual curtilage areas have been identified now within which all outdoor domestic activity has to occur. So outside of those curtilage areas, the individual lots will be more or less paddock land. And then we've also introduced the vegetation management areas, which is the red hatch at the end of the plan, at the end of the key. And those are the more exposed escarpment pieces of the site. And they are to be managed so that pests are controlled, existing native vegetation is retained, existing exotic vegetation other than pasture grass is removed. So really that will entail removing gorse and broom and briar rose and maintaining them as open grasslands with native remnants in them. And then, as I've said, in addition to this, there's a vegetation management plan condition proposed. So if we come to my evidence, I'm just looking for the right part. I'm at paragraph 12 of my evidence. A condition is adopted that requires a vegetation management plan to be submitted and approved. This is a consent notice condition. And as per Mr. Vivian's recommended condition in this regard, the vegetation management plan shall be required to give details of the existing vegetation within each of the existing vegetation to be retained areas, identify any vegetation that needs to be removed for safety. So that would take account of particularly mature poplars, if there are any in close proximity to building platforms and things. In relation to each existing vegetation area to be retained, set out what ongoing maintenance and or pest control work should be done, set out what successional planting shall be done to ensure a 10-metre high screening effect is maintained at all times, so that the shelter belts and things can be trimmed, but they can only be trimmed to 10 metres or so. And that's often desirable anyway. And so the succession vegetation shall include details of species, location, amount and timing of new planting and an incremental staged felling of aging trees. So that vegetation management plan is something that the applicant or the consent holder would have to prepare and submit to the council, and it would set out how that works to be done. I mean, it's probably a relatively simple plan, but it sets out timing and things to do with the successional planting, and then that can be monitored by the council. But that vegetation management plan is proposed to be provided in response to a condition of consent. A couple of other points that I sort of picked up on this morning that might be useful is to do with, as Mr. Todd points out, we now have the PDP provisions to do with priority areas and to do with scheduling or setting up the values of the priority areas. And the Cadrona Valley is one of the priority areas, ONL. And so, as Mr. Todd says, Council is currently doing work to document the values of these various ONLs. At the same time as the PDP is being resolved, the Institute of Landscape Architects has finalised a guideline document to do with landscape assessment work. And that's been a long time in process, and we've been working away on that for years, but it's now finalised. And it defines some key terms. The definitions aren't new, but it does define things such as landscape character and landscape values. And an easy way of thinking about it is that there's a pattern of landscape elements. Any given landscape has a pattern of elements that make up that landscape. And the unique pattern of elements in any given landscape that define that landscape, that's the landscape character of that landscape. And then we have the issue of landscape values, which values, of course, aren't things that you can find out in the landscape. Values are held by human beings. So humans value landscapes. And so in short, the landscape values of a landscape are the reasons why people value it. They're the things about it that are valuable. So landscape values are inextricably linked to actual things in the landscape, but the values themselves are held by humans, and it's why people value the landscape. So in my evidence, really around around paragraph 25 down through to probably paragraph 30. I'm talking about the landscape character effects of the proposal and what the character of the Cardrona Valley is. And also in the original assessment report that formed part of the application, there was a section on the existing character and values of the Cardrona Valley. And Mr. Todd kind of summarised it. In many ways, the valley to the south of Cardrona Township is a high country, very unmodified valley with no real valley floor, whereas the valley from Cardrona Township to Wanaka has quite an arable valley floor, which has verdant paddocks and Lombardy poplars as a key characteristics of it. And then there are the valley walls that are much less farmed, of course. So the reasons that people value the Cardrona Valley are certainly to do with its high natural character and its remarkable aesthetics that come from the mountain peaks and ranges, but also people value the farmed valley floor with the poplars and the paddocks and the farmhouses and the hay barns and the nodes of traditional development. People value these things. And so the nodes of development that we see at the mouths of side valleys are part of the character and part of the values of the Cardrona Valley. And I'd expect to see that noted ultimately in whatever schedule comes out, setting out the values. As Commissioner Nixon pointed out, it might end up being something similar to the LCU schedules that we have for the Wakatipu Basin. And again, of course, some of the things that are noted in those schedules as being characteristics to be maintained, it's not just purely natural characteristics, it's sometimes cultural characteristics as well, to do with settlement patterns and traditional use and what have you. The other point, I guess, that to do with landscape issues that came from Mr. Todd's submissions was to do with the reasonably difficult to see policy. And we've got 6.3.3.1, and as Mr. Todd was saying, the second part of that, part B, is to do with this reasonably difficult to see issue. And of course, the words can be interpreted in a few ways, and reasonably difficult is a subjective sort of a term. And I guess it doesn't contemplate invisibility, and it doesn't contemplate that things cannot be seen at all. And so beyond the site's boundary, in the paper road, for example, there are spots where if you stand in the right place and look in the right direction, you'll see development. But these aren't locations that people go to, and they aren't locations that are terribly easy to access. So in the round, you could say, well, it's certainly reasonably difficult to see in the round. Very few people go to these places. It's probably quite hard to get to these places. So in the round, things are reasonably difficult to see. And I take a little bit of guidance in that from the assessment matters of the rural zone. I'm looking at assessment matters 21.21.1.4, which are assessment matters to do with outstanding natural landscapes. And the policy to do with reasonably difficult to see, of course, is in part 6 of the plan. And there's various chapters underneath that. The only assessment matters that actually refer to reasonably difficult to see are these ones in 21.21.1.4. And
excuse me, Mr. Espy, you're referring to the very latest version that the court released back on the 24th of May?
Yes, I believe I am.
Okay, that's fine.
If I'm looking at the right thing. And those assessment matters there, I mean, so as I say, these apply to ONLs and not non-ONLs. So these are the only assessment matters that refer to reasonably difficult to see, and they say the extent to which proposed development will not be visible or will be reasonably difficult to see when viewed from public roads and public places. In the case of proposed development in the vicinity of unformed legal roads, the council should consider the present use, practicalities and likelihood of potential future use, for vehicular access, pedestrian, cycle, equestrian. So that there is indicating that you consider whether the place is used or not. So some consideration of the nature of these viewpoints is part of the consideration. Then assessment matter B, whether the proposed development will be visually prominent such that it detracts from public or private views within outstanding natural features and landscapes. So again, it's asking whether it's prominent or not. So it indicates to me that when considering reasonably difficult to see, you're considering things like, is it prominent? You're considering what is the nature of the place that people are viewing it from, and how accessed it is. And that all comes into the consideration of reasonably difficult. So the conclusion I have in my evidence and in the assessment report is that this is reasonably difficult to see. That's all the comments I had, but I'm happy to be directed to whatever questions you have.
Okay, thank you, Mr. Espy. Well, while we're on the assessment matters at chapter 21, so you've referred to the ONL one. I haven't actually got them in front of me, which I meant to, but you're obviously aware that the court has released its decision, so those are now, I suppose, operative in their amended form, which they have been amended in particular. The test, I think it's in the cumulative effects one, has gone from the council must be satisfied back to the sort of ODP test that they must have regard to. The various, yes. So I just wonder, so we sort of dealt with the reasonably difficult to see, but with regards to, it's really, I guess my question then is really around how do you, if you accept that nodes are anticipated in this landscape, as you've described, how do you actually assess what the node should be, how big it should be, and when and the density of development within that node, and the cumulative effects, I suppose, in terms of, well, when is the threshold reached? Because I think that is one of the differences, and I know that we haven't heard from council officers in respect of the amended application, but certainly with the first application, it was, I think, I'm paraphrasing here, but there was an ability to absorb some development, but not all. So I'm sort of interested in your views on those, and they are covered by those two assessment criteria that now we do need to look at.
Yeah, well, I think it comes back to the values of the landscape itself and how those values will be affected. And of course on the individual nature of the proposed development. In somewhere like the Cadrona Valley, I think if you put development in the wrong location, one house can be too much, you know. But if you put it in the correct location, a number of houses may well be appropriate. And this is because of the way people value it. People value the open mountain slope parts of the Cadrona Valley and the overall picture that somebody gets when they drive through the Cadrona Valley. But development in the appropriate location in side valleys and things won't fundamentally affect the way that people value it. So I think we keep having to keep coming back to that question. And if we're dealing with cumulative effects, it's the same question. If too much development is done, then that will affect people's values. So it's at that point that values really become affected. And I mean, I guess I can only speak to the individual specific development that's in front of us, and you know, to me that's not tipping any threshold of affecting people's values. Certainly potentially other development could, and too much development certainly could. That's definitely correct.
And you have no concerns then in relation to the density of the proposed development?
Well, density per se, I don't know. I mean, I actually think sometimes in these sorts of situations, a denser, tighter development is better, yes, than a sprawling development. So if we are expanding on an existing node and doing that appropriately, then density per se I don't think is a key consideration.
Thank you. Fire ahead.
Just, we talked about the node before, and originally our understanding was that lot 1 was possibly going to be, if I can use the term, farm base, but now we understand it's more likely to be lot 5. Looking at it from our site visit yesterday and looking at the plans, lot 1 now looks to be something of an outlier. It's not really part of the node at all. It's a house alongside the road, basically. So I'm just wondering what your thoughts were on that.
Well, I guess the original intention, was that the lot 1 platform, what's now the lot 1 platform, sat on a bigger lot. Through the assessment of the original proposal, the council staff and also Mr. Vivian and myself felt that platform and that location was quite appropriate, and so that hasn't really been proposed to change. There's more planting around it now than there was. So I mean, I accept that spatially it's a little bit removed. It depends, of course, on what scale you look at it. It's still accessed by existing farm tracks from this farm base area, and it's in a sort of a small paddock that is almost a home paddock. Yeah, I mean, I don't think it's causing any adverse effects by being a little bit further away. If it was in an exposed area, such as the paddock now down near the location of the junction of the Paper Road and Cadrona Valley Road, then I think it will be causing problems. But where it is and because of its nature, I think its effects are appropriate.
So is that based on putting weight on existing vegetation? So, for example, someone in the future decided to come along and put a house on the corner of the legal road and the main road down the valley on that corner there, and said, well, I'll just put a mound up and plant some trees on it. You can't see me, no problem. Is that reasonably, would you find that a supportable proposition?
Well, I think probably not. I mean, that would be taking away a visible and appreciable area of paddock land right beside the road that is currently seen and allows this little view. The lot 1 platform has this existing vegetation, certainly, which is an important part of it. Also proposed vegetation, but also topographically, it sits higher up in the road on a sort of a little shelf that's a bit removed from the road. So, you know, I think topography, existing vegetation, proposed vegetation are the keys there that the other paddock doesn't have.
So in many cases, it would be like a combination of factors which make a site suitable, like topography and vegetation, or maybe some other factor in vegetation, or, you know, rather than relying on one single aspect.
Yeah, yes, absolutely. Yep.
You may have covered this already. I presume this area would be very drought prone in summer in terms of planting vegetation, particularly native vegetation. It's not an area I've had any experience in before, but how easy would it be to grow there, particularly if it wasn't irrigated?
Yeah, well, we've proposed automatic irrigation to all the new plantings, and there's water to do that, and that can be done fairly easily. Really, that irrigation would be drippers over the hot months of summer, and that's really all it would be. The idea is to prevent plants from getting dried out and dying during those very hot months of summer, but don't irrigate them so much that they become reliant on the water, kind of thing. So it's minimal irrigation, but it's important irrigation. In some of these other locations, such as Rob Rosa and Spots Creek, very similar vegetation to this has been done, sometimes without irrigation at all, and it's provided the right species are chosen, which are the species we've got here. They grow and they survive. They're fairly slow at the start, You know, it is a slower place for vegetation than sunnier locations, definitely. But vegetation survives and does get going. And in the case of some of these plants, it's a matter of them getting their roots down to sufficient level to access groundwater, which can take some years. But then when they do, sometimes in year 7 or 8, they suddenly start growing quite quickly.
Yeah, one of the reasons I asked that was that on our site visit yesterday, which is probably a bit of an atypical time, there's about 6 to 8 inches of snow on the ground, so it makes a slightly different impact. But it did seem to us that a lot of the existing trees looked a wee bit threadbare and tired. So are you confident that you can sort of plant in and around those and supplement them, presumably on the basis that when some of the big old pines or poplars finally give up the ghost, that there's something going to be there to replace them?
Yeah, I think that's right. Yep, that's right. And that's the idea of the successional plan.
Right. I take it you've based, when you undertook what appears to be the case, when you undertook your visual assessment, I think the same is true of Mr. Denny, that you have undertaken that assessment on the basis that the effects you're taking into account would include a future building, if I could put it that way, on the building platforms.
Yes, certainly have done that. Yep, that's right. To the maximum heights that the building platforms are providing for.
Sure, understand that.
Excuse me, I was going to ask this question of Mr. Vivian, but and I thought, I can't find it now, I thought I had read in the evidence, pre-circulated evidence, that there were some covenants or consent notice, preventing any further subdivision. Are there, is that, so sorry, I have found that, it's Mr. Vivian's evidence at 2.28. But that doesn't apply to lot 5, obviously, as it's worded. With the balance lot 5, you know, given the importance of maintaining the ONL and the values, if the development, you know, was to be consented in the sort of node of development, and I'm sort of, by that I'm sort of looking at the building platforms. What I guess protections do you think are appropriate for the balance? If we, and I'm talking here from a perspective of maintaining the ONL values.
Yes, yeah. Well, I mean, I suppose the overall point in response to that is the provisions of the district plan do a very good job of doing that. You know, they're very comprehensive and they're pretty onerous. I imagine if this gets granted, there'll be conditions about, you know, dwellings need to be inside the building platforms, curtilage needs to be inside the curtilage area. So that will be setting up a situation whereby lot 5 has one residential unit and a curtilage area around it, and the rest of it is farmland. Yeah, I mean, it's hard to look into the future and you know, we set up these consents and then in 20 years' time, the environment is quite different. Yeah, I don't know, other than the district plan, as we've seen going through all this today, the district plan is pretty comprehensive in protecting landscapes. I've got, you know, I don't have any doubt that inappropriate development would be refused.
Tempted to say no kidding, but I'll try and restrain myself. Or I try to. Yes, there's quite a lot of material to work through, that's for sure.
Yes, and I think, and it's been said in the evidence here, and I think certainly the Environment Court has said that the proposed district plan, it does tighten up on the protection of ONL. I mean, I guess the policy direction is very clear. And, you know, I guess it falls down to, you know, when you're starting to put that into practice, how does that translate to, you know, if you are going to allow development within a node. That's why I was interested in the question about the threshold, which I don't think you've actually answered. And you've said it doesn't reach the threshold, but it doesn't sort of give me any indication of what the threshold might be if you were to judge that today.
Well, I think the problem is it's not a problem, but I think the fact is the threshold changes as decades go past. The population of this district only goes one way, and what we were considering 20 years ago is very different to what we're considering today, and I can't imagine what we'll be considering in another 20, 30, 40 years' time. So I've yet to see any consent that sets up a position for the future that remains there forever in an appropriate way. I think we have to have faith in future processes under either this district plan or future district plans.
At one level I agree with that. I think you could argue that the threshold now is probably less than it was 20 years ago for these OEL areas based on the plan. So to some degree, and it could in 20 years' time, it could be even tighter again because these areas may become scarcer and more valued by people in the United States. So it goes. I guess it can go both ways. It's probably one of the most difficult things that you grapple with when making these decisions as to what is appropriate, and obviously that's informed by the plan and how. But there's a lot of judgments required in how you interpret that. So and people placing limitations on what is appropriate is not uncommon by way of covenants and that kind of thing. And again, those are not fixed in concrete. They're a discretionary activity to actually change those or remove consent notice conditions, for example. It's a discretionary activity. So it doesn't mean it's fixed in concrete for all time if there is a case down the track for removing it. So it's probably nothing more you can add at this stage, I think.
No, I've only got one other question I forgot to ask earlier. Now, on your landscape plan, page 168, I think I've interpreted it correctly. You've got proposed curtilage area, which I think is a sort of yellowy green colour around each building platform.
Yes.
On the face of it, they look very large, and I was just thinking, and I realise you're relying on it being not very visible, but thinking of a certain Mr. Howarth who would come along to hearings and say, well, what about the effect of visual clutter? Now, I suppose if you look at those areas, if they ended up with containers plonked on them and that kind of thing, which sometimes can happen, it could become fairly untidy. I'm just wondering why those areas have been selected to be so large.
Well, the curtilage areas won't enable anything to happen that would require resource consent. Any structure is going to require a resource consent. If you want to put a shipping container there, you'll need resource consent. If you want to build a pergola, you'll need resource consent. So they don't enable anything that's not otherwise enabled. All they do is place restrictions on the area outside the curtilage area, such that outdoor domestic activities have to be inside the curtilage area. So permitted activities such as, paved areas and barbecue areas and outdoor seating areas, they're not allowed outside the curtilage area. Ordinarily, you can do those anywhere you like, of course, because they don't need resource consent. So the curtilage areas don't enable anything that would require resource consent. They're just saying that outside the curtilage areas, domestic activities aren't permitted. So, I don't expect anyone would develop their curtilage area in some visible way on the ground so that their curtilage area is paving and umbrellas and this and that and the other thing. They're far too big for that. I don't envisage anyone would do that. It's just restricting development outside the curtilage areas, really. I mean, it may well be, after all, those building platforms on the flats, there are 800 square metres. It may well be that the house and garden and walls and paved areas are all entirely within that 800 square metre area.
No. Thank you very much, Mr. Eastby. That's been really helpful.
Thank you.
Actually, I might just at this point, Mr. Todd, now we've got Mr. Denny here, just ask Mr. Denny if he has any questions of clarification. So only, not as Mr. Jones, we've sort of got a bit more into the substance there, but that was really so that Mr. Jones could leave. But Mr. Denny, I assume you'll be staying through to the end of the hearing anyway. So if you've got any questions of clarification that you'd like to ask at this stage.
They caught me unaware, to be honest.
Sorry, you don't need to. You can pass on the opportunity.
No, not at this stage. I'll probably have comment later on.
No, that's right. It was just if you had any questions in relation to what the changes. That's all. Yeah.
All right. In terms of the management plan and removal of unsafe trees and protection of existing trees, is there any indication of what percentage of the existing vegetation is wildling species like Douglas fir and what potentially could be unsafe trees?
As far as unsafe trees go, the poplars that are closest to the proposed building platforms, to my eye, don't look particularly unsafe. I imagine when we come to do this, if somebody comes to do a vegetation management plan in response to this condition, they'll engage an arborist to look at all this. And so there may be some of the very mature poplars that need to come out, but it looks to me that they're far away from buildings anyway and probably aren't serving a vital purpose. So that's the unsafe trees aspect. The conifers that are protected, most of those are pines, and I think it's a ponderosa pine, or it's a large cone pine. So I don't see that any of those will be on a wilding list. There may be some Douglas fir in there that it would be preferable to remove. But as I say, the important stuff that is providing screening doesn't look like that. So I anticipate that the vegetation management plan would look at all those issues and set all that out and set out successional planting. So I see that the vegetation management plan would capture those questions.
Okay, thanks.
Okay, right, thank you. Mr. Todd.
Yes, ask Mr. Vivian to just answer any questions or summarise the evidence.
You're welcome, Mr. Vivian. Thank you. Again, if you could possibly, we can take your evidence as read, but if you would just like to summarise and just touch on any key matters, particularly in the context of the discussions we've already had today, that would be really helpful.
Okay, thank you. I'll just start off by saying I've got COVID as well, so
okay.
My brain's not working terribly great, but I'll certainly try my best to assist you.
Oh, that's all right. No.
I'm not quite as sharp as Mr. Todd.
Okay, no. Well, look, yes, just whatever you'd like to touch on.
Yep, no, that's fine.
I think we've got a few questions. So
yeah, essentially, after we received the Section 42A report, we met with Mr. Neves and Mr. Denny on site and looked at the options here and came up with what we thought was a good solution to take 2 of the 3 lots off the terrace, which seemed to be of most concern to Mr. Denny and Mr. Neve, and create more of a farm-based node as it is on the flatter ground, and my evidence is quite awkward in that Mr. Neves had I addressed the concerns of Mr. Neve, but he was looking at a slightly different proposal, but so I've sort of had to take the parts of what Mr. Neve considered were acceptable and build on that through my evidence. Really, I think that you've got a pretty good understanding on the amendments to the proposal now. through those questions of other witnesses. Yeah, the main issue that I see comes down to that one policy about reasonably difficult to see from outside the boundary of the site, which is sort of followed through from the operative district plan Wakatipu Basin ONL policies, which in some respects were a lot even easier than this, because they were restricted to public viewpoints, not any viewpoints, which this policy seems to do. So yeah, it does set a very high threshold for development of the district-wide ONL, and my evidence essentially comes to the conclusion that the amended proposal achieves that threshold and should be granted.
Thank you. So just on that point, Mr. Vivian, I think in your pre-circulated evidence at paragraph 8.71, you talk about this, and then you talk about relatively plainly.
Yes.
Which is in italics.
Yeah, that they were words that Mr. Espy used in
Yes.
his assessment.
Yes. Right, and this is just from the unformed legal road. Okay.
Yes, that's correct.
Yeah. All right, thank you. I think it's questions, Bob, before I keep on.
Yeah, just one. It's from reading through all the evidence prior to the hearing, it seemed there were two primary bases for the application, or some support of the application. One was the visibility situation, where I think we'd probably accept that we've visited the site. It is a fleeting view in that direction. Yes. That's one aspect of it, I suppose. And the other is that there is a node that can be built on. Now, we did have some sort of mulling that one over a little bit, because having been out there, there's an existing dwelling there on the neighbour's property, the one that's now been sold.
Yes.
Apart from that, there didn't seem to be much substance to the buildings that were there. In fact, some of them we saw appeared to be quite small and even derelict condition.
Yes.
I'm just wondering how strong that nodal argument might be in this case. Now, we know that in the case of this property, the main farm base is, I think I understand, further north in the Branch Creek Valley. It seems to me it does rely fairly heavily on the presence of the existing dwelling on the neighbour's lot to provide that basis.
Yes, I guess in terms of buildings, I would agree. There is to the east of Lot 1, to the west, sorry, of Lot 1, there is a small shed building with an old tractor or something in it, I think. And then there are some smaller buildings sort of dotted through that field area, including some sheep yards and some silos from memory, or a silo or two. Yeah, so but in addition to that, I think the vegetation reads as a node as well. It's certainly I'm just thinking about where the main activity of the property on the pastoral lease occurs. When you drive into that area, it is very similar, although there are more buildings, more farm buildings sort of scattered around a larger area. So yeah, certainly the vegetation, I think, helps a lot in terms of defining a nodal area.
In terms of, I asked this question earlier, but when you prepared your assessment, and I think Mr. Neves has done the same, you have, in assessing the effects of the proposal against the objectives and policies, you have taken into account the effects that would occur once a building is established on the building platforms.
Yes, Mr. Todd submitted earlier that you would have to come back as a controlled activity to build within the building platforms. That isn't my understanding under the proposed district plan. Under the proposed district plan, there's got standards built into the external appearance of buildings, heights, etc. And my understanding is that in the rural district wide, it is actually a permitted activity to build within an approved building platform within those standards in the plan. So your external appearance, your glare, etc., etc. And that is a change from the ODP regime to the PDP regime.
Yes.
It is, yeah, it is. I appreciate Mr. Todd being a bit confused on the issue, because in the Wakatipi Basin it's different, in the rural lifestyle zones it's different, and then in the rural, what's left over of the rural zone is different as well now.
I think we're all confused on this one. So,
Yes.
Yeah, but certainly it does appear that it is a permitted activity to build within an approved building platform, provided you meet the standards in the plan.
Yeah, and I think both some of Mr. Neves would anticipate that if consent was granted, there would be conditions on external materials, reflectivity,
Yes.
the standard kind of things you would be aware of.
Yes, although I have said in my evidence that those conditions probably aren't necessary anymore because they are standards in the plan, and we can rely on that fact.
Yeah. Okay.
Mr. Vivian, I guess I sort of asked Mr. Espy sort of this, but I guess so. Part of the, I guess going back to the landscape values and people's perception of value, and the node argument, and you've actually referred to it in your introduction as this is a farm-based node, and it's very clear that there has been a settlement pattern of farm-based nodes, especially to the north of Cardrona Township as we head towards Wanaka. I think I've got that right way, heading north. And so if you accept that, yes, that those settlement patterns do occur, but that they are very much, grounded in this being a farming node for farming activities. And that's not to say that, but some farming activities does envisage, residential development associated with that, because obviously you have the owners of property, you have farm workers, shearers, quarters, all of those things traditionally associated with that. Yep. When we get to subdivision, I suppose, and this is harking back to this 21, I've now lost, chapter 21, and the I think it's at the very beginning of your evidence on the that it is contemplated that farm owners do need to provide for their long-term sustainable farming operations. I guess so. If you accept all of that and you say, right, and then the logic is, well, right, well, as part of that, there may be some opportunity for a subdivision and for residential development that's not necessarily associated with the workings of the farm. But yes, in this case, we have the potential here for the entirety of lot 5 to effectively no longer be part of the working farm, if that was to be sold independently, and there's nothing proposed that would stop it. It's not being proposed to be amalgamated. I don't even think it could be amalgamated into the ground pastoral lease. Stands on its own. How, if we're looking at the landscape values and what we're trying to protect and maintain here, do you think the current proposal does that in its current state, given the flexibility there is around around these titles? And will that well, the original premise of this, and that it is a node that's reflective of farming, is that still likely to be maintained in your?
Yes, I do have a lot of faith in the district plan in terms of its ability to protect landscape values and the character of the landscape, and that is evident in this process that we're going through now. The proposed district plan in particular is even stronger than the operative district plan, and I've given a lot of thought to whether lot 5 should have a consent notice on it, no further subdivision, which lots 1 to 4, with the exception of my minor boundary adjustments, do. And really, in my view, the consent notices on a larger parcel of land do very little, because any subdivision is discretionary in any case. Certainly, I think it's beneficial to maintain the amalgamation between lot 3, I think it is, and
yes, lot 4. I think lot 5, proposed lot 5, and then
proposed lot 4 and 5. When we initially looked at the application, it was if you didn't identify a building platform on that balance title, it was in fact a non-complying activity. And that is the reason that we proposed the building platform. I think it was on what is now lot 1. I can't remember what the lot number was then. So a building platform was maintained over the balance of the property, and the proposal maintained discretionary activity status. I understand that rule hasn't survived through the PDP process, so you can in fact create titles without necessarily having to identify building platforms. That said, I agree with Mr. Espy that I still think it's preferable to identify a building platform, because the consent notice directs all activity to that building platform, as opposed to other areas of the site which may be less appropriate. An example of that is on certain size properties in the rural area, you can put farm buildings as a permitted activity. Yes. I'm not sure off the top of my head if this qualifies, but certainly that consent notice would direct that farm building to be placed within that building platform, not outside of the platform. So there are some benefits in having that platform there.
Yes, I'm not probably so much concerned about whether there's a platform or not on lot 5. It was really about how do we, if we were to say, okay, we accept that this is an appropriate level of development, how do we then, I suppose, for the balance of lot 5, ensure that maintains the landscape values that are inherent in what is a farming operation, as opposed to.
Well, I guess the options are: there's consent notice, which is a type of covenant, a covenant, and thirdly the district plan provisions, which, as I've said, I have faith in that will protect those values.
Yeah, I guess that would certainly. I mean, obviously, if any further the subdivision or development was applied for, that would certainly come under that. But it was really around, I suppose, what you can do as of right on that land, and yeah, I have to give some more thought. I might come back with a question on that once I get my own thoughts on that.
Okay.
It was really to do with, given the I guess the evidence has been around the node, and that it is a farm-based node. So how do we, if the development was to be consented, how does it remain? I suppose how does it remain with the appearance of a farm-based node that's in a way that's not going to detract from those ONL values that it's currently exhibits. So it's probably to do with the wider uses of that balance lot, and it may be, for example, that, well, actually, if it was going to be continued to be farmed in a productive way, because I think there is an issue around loss of productive farmland as well. Maybe that irrigation water does need to stay with Lot 5. The combination of those sorts of things that would actually encourage some kind of traditional, it doesn't have to be traditional, it could be some kind of regenerative agriculture, but of the future, that because I don't understand there to be, for example, an agreement that the run holder for the Crown Pastoral Lease would necessarily farm that, but of course agreement could be reached on that if it was to be sold, that is. So I mean, it's all of those sort of things. So that's just what's sort of milling around in my mind at the moment.
Yeah, I understand what you're saying.
Yeah. So
Mr. Todd alluded to the fact that I've been involved in Plan Change 13 in the Mackenzie Basin for about 13 years, and and yeah, it is a very similar issue to what they dealt with in terms of identifying farm-based areas, and then enabling development to occur within those farm-based areas while protecting everything around it. And the actual what they're allowed to do in farm-based areas is quite enabling in terms of rural residential development, commercial development, visitor accommodation, but I think that the real difference between the Mackenzie situation and Queenstown is in Mackenzie there's only 37 landowners, and most of the high country stations are enormous, and so the farm-based areas that they've got, some of them are in excess of 80 hectares in area, so they're as big as some of our lifestyle zones in effect. But at the scale that we're talking, that the landscape can accommodate that. Certainly in this situation, the farm-based area, in my view, is a lot smaller scale than what we're dealing with up there. But it's still got all of the distance between the building platforms, the topography, the vegetation. It's still got all the hallmarks of what a farm-based area is expected to be in the rural area.
Yeah.
So there's no comparable provisions in Chapter 21 to those that you're aware of under Mackenzie?
No, we for Lachlan Station through the PDP process, we actually submitted that this concept of farm-based area should be introduced to high country stations in Queenstown, but the council planners didn't want to do that. They didn't recommend it. Lachlan actually appealed the council's decision to the Environment Court, and council actually refused to go to mediation on it, and therefore they ended up just withdrawing because they couldn't make any headway with the council in terms of looking at the concept.
Yes, I think you touched on the key point is, if you, even at, the conceptual level, if you say this is a farm-based node, then, what is the scale at which the landscape can absorb it, and then how do we then, I guess, given that it's such a large balance lot, how do we then maintain the landscape character and values associated with that, that people do actually value? That's what's milling around in my mind.
Yeah, because it could go beyond. I mean, I think, look, as long as the existing trees can be retained successfully, given their condition, and they're supplemented by further planting, I think we can certainly accept that lots 2 to 5, and they're not going to be particularly visible. If you're whizzing along Cardrona Valley Road, you might just pick it up for a short distance about you cross the bridge over Boundary Creek. Other than that, you can't see it. But I suppose that the thought goes to the back of our mind is that, are there any other issues besides just whether it can be seen or not? In other words, the intrinsic issue of having a cluster of new houses in a part of an ONL, even if it can't be seen, that's something I think we have to turn our minds to.
Yes, definitely.
Yeah. All right. Well, thank you very much, Mr. Vivian. Do you have any further questions?
No, very helpful.
I'm aware that you're not well, so I don't want to.
Oh no, that's all right. There was one issue that was picked up that I picked up earlier in terms of the existing water supply, and I think Issy is still with Ben, and she might be able to explain it further. But at the moment, the existing bore has a regional council consent, and it's in the name of a water company. And it was proposed that the owners of lot 100 would have 1/5 shares, or 1/6 shares, I think it is, of lot 100. An alternative way of doing that would be that the water company own lot 100, and each of the owners has a share in the water company. So I think I have addressed that in my evidence somewhere, that in terms of an OR. I haven't actually had the opportunity to discuss that with Mr. Todd, but I assume that still meets that option still meets his concerns in terms of the new water legislation. I'll see if I can find it. It was.
I think I do remember reading something like that actually.
Oh yeah, on paragraph 2.25. So the Boundary Creek Water Management Company is in existence, and they would attribute shares.
Yes. Okay.
And I understand from Issy that company own all the physical infrastructure in terms of the bore and the pipes in the ground, etc. as well.
Okay, thank you.
Would that be the water source for the irrigation that will be required? And who would ensure that the irrigation?
Perhaps that would be a good question for Issy, but I understand that irrigation water comes from way up the valley further, because it would, feed naturally down the valley, rather than pump it up the valley. But Issy may be able to answer that question.
And write a reply, Mr. Todd, you could just fill us in that small detail.
Yes. I think that is quite important actually, in terms of where the water sources come from, and if irrigation water is to be maintained to the balanced lot, that would be good if that could be addressed. Sorry, Mr. Vivian, I did have one other question that I was going to raise with you, and this was the comment in paragraph 8.61, and you talk here about cumulative effects being an important consideration, which is, and I guess I wondered, so in this sense, you were actually talking about cumulative effects more broadly for the district, because you're looking here at the township. Yeah. So how in your expert opinion, how should we be considering cumulative effects in terms of, and I'm thinking here in particular around the assessment criteria in chapter 21. Does that go as far as, I guess this?
Yes, it does. There's certainly policies in terms of cumulative effects. In my view, the cumulative effects are to some degree resolved by the reasonably difficult to see test. If it is truly reasonably difficult to see, then cumulatively, from a landscape point of view, it shouldn't be an issue. There are, as Commissioner Nixon pointed out before, visibility isn't the only consideration, of course. There is the fact that there potentially is 5 more buildings in this location, irrespective of whether they're visible or not. And that's where in paragraph 8.61 I have tried to look at the cumulative effects from a wider point of view.
Right. Okay, thank you. That's very helpful. All right, thank you. No further questions. Thank you.
Okay.
So, Mr. Todd.
Yes, that's the case for the applicant.
Okay, thank you, Mr. Todd. Yes, I think at this stage, given that we've been going for nearly an hour and a quarter, I think we may, and to give the officers a bit of a chance to have a chat before we hear from them. We might just take a adjournment. I'll just ask Mr. Neves how long if you would like.
15 minutes.
10 minutes.
Oh, yeah, 10 to 15. 10 to 15.
15. All right, why don't we reconvene at 5:02?
Perfect.
Okay, thank you. We'll adjourn till then. Thank you very much.
Howdy. I think that went okay, yeah.
You there, Kerry?
Graham, have you got a minute to talk?
Yep.
I was just talking to Issy about the irrigation water.
Yep.
And she said that the irrigation water source is actually on the pastoral lease.
Okay. All right. We can deal with that in a reply anyway. We don't need to.
Yeah, okay.
Yep.
Yeah. All
Okay.
right.
Thanks. Kerry, what time are we starting again?
Supposed to be 5:02, I thought.
Yeah, I thought so too.
Oh, here we go.
Sorry, yes, we are starting. We were going to start at 5:02, except that I was just waiting for the officers to
Oh, sorry.
I should have turned ours back on as well.
Apologies, commissioners.
That's my fault. I should have done that.
Commissioner,
all right.
can I just check, are we actually recording this rather than YouTube? Is there actually a audio recording?
Yes, there is, Graham.
Thank
It's
you.
recorded, which will be downloaded as well as the YouTube.
Thank you
option.
very much. Just saves me taking a lot of notes.
Lovely. Thank you. All right. Well, thank you, Mr. Lease. I'll hand over to you and the first instance.
Thank you. I think we'll start with Mr. Denny, let him go through the expert landscape side of it first.
All right. Thank you.
I'll just go through the notes from this morning first and answer any questions on my report. In terms of the proposed amended development, it's of a similar nature and scale to that originally proposed, so that's been taken into consideration. Key changes to me are, excuse me, there's a new lot and dwelling closer to the existing dwelling on neighbouring property, and that access road will serve a total of 4 platforms rather than 2. There's comments this morning on the effects of subdivision. To my mind, the change in the size of lots and the scale of lots results in the change of land use, which results in the change of landscape characteristics, all which have an effect on the landscape as such. And that's without a platform in place. So subdivision to me does have an effect on landscape, especially in a context of this, of large lots that we're now.
Right. So sorry, just to dive into that. So you're saying subdivision does have an effect on landscape because it might lead to land use change, is that
Yeah, the way people use a land parcel depending on its size.
Exactly. Yes.
Change in land use, and that affects the change in landscape character. And to my mind, it's quite a large driver for landscape change in the district as well, subdivision.
Right, so hang on. Yes, okay, understand, thank you.
Existing rural node as such, trees and buildings, contributes to the rural landscape character and values. So there's an opportunity, obviously, to build on that. But to my mind, 6 dwellings in the change from a rural character node as such to a node of 6 dwellings is quite a substantial leap as such. And that has an effect on landscape character as well. The proposed, sorry,
I suppose yes, but in what way and what is the magnitude of that effect, I suppose?
Yeah, I think I've discussed that in the report. To me, the existing node is relatively inert, I guess you'd say. There's one dwelling there that's been subdivided off.
Yes.
A couple of sort of older farm buildings and established trees in there. So it's kind of a relatively low-key, peaceful little node of trees and what have you. The change from that to 6 residential dwellings with construction that comes with that, with upgrades of roads, with fencing, domestic activity, noise, lights, smoke, sounds, lawnmowers, all that sort of carry on, domestic planting, all that sort of carry on. That changes that node in terms of its character. And that will have an influence on the surrounding landscape. Even though potentially you may not see all the buildings, that change in landscape character of each of those small parcels will have an effect as such, I believe. The proposed condition for a management plan, which enables some modification to the existing context to suit residential development. So we've got a potential removal of unsafe trees, which can be a hazard to dwellings, so they could potentially come down. And some of those trees are quite old. we don't have a real fixed figure on how many trees may be removed, so there's potential change there. There's also provision there for trimming of trees. So again, there's a shift away from a traditional rural character to one that's more catered towards residential development. Discussion on the existing paper road. I've touched on this in my report as well, and haven't put a lot of weight on it, but currently there's no existing use for it, and it's obviously, as the landowners said, there's been no observed use of it. But the road is still there, it hasn't been discontinued, and so there's provision there for a future road, and probably more likely, I would have thought, provision for a potential cycleway walkway, because this connection goes from the Cadrona Valley Road. Just down the road is another unformed legal road to the river. There's a connection there. And this unformed legal road also connects through to the Mount Cadrona Station Special Zone, which has got much higher density of development there. So the desirability of a recreational trail through there, I would have thought is quite high. I'm not aware of any proposal as such, but the provision's there to enable that to potentially happen. So I think it's still something to be considered as such. Just with regards to lot one, just to raise the matter of fire risk and planting and mitigation. I think the other lots are pretty good. They've got quite a clear setback from planting as such. The general guideline from the New Zealand Fire Emergency Service is a 10-metre setback of clear zone. For lot one, it's getting a bit tight. There's potential fire risk there in terms of mitigation planting. So it'd be good to see some adaptation with the planting there to low flammability species and having some clearance around some of the trees. I think that can be adapted in there. The proposed coolage areas, they are quite large and the lots are quite small. So effectively the balance of the lot, I would suggest, is not really going to contribute to rural character at all. It's going to be more likely to be used as further domestic activities and stuff. It's almost a point of the lot size of that small that is there any purpose to have a coolage area. The lot boundaries I consider not to be logical, especially for lot 2, 5, 3, and actually just those 3. And lot 1 as well. Ideally, the lot boundaries would follow natural lines in the landscape, which would be the toe of this slope. So that whole natural landscape unit, which is the hillside, is maintained as one unit and managed as one unit, which maintains the cohesive landscape character as such, which you really expect in an O&L context. And that's one of the defining characteristics of an O&L, is this large-scale cohesion. Putting a boundary along that's like, I think it's going to contradict that sort of outcome. And same for lot 1 to a degree, I would have thought too. I think the boundary should be along the toe of the slope rather than taking off a small parcel of the hillside to be connected to a dwelling in a residential rural lifestyle land use. I know there's controls on that to remove weeds and stuff and plant only native, but regardless of that, I think there's still activities that will happen on that slope that'll be different to what's around it, and that'll make it stand out and highlight some of the fragmentation of the landscape, which you generally try to avoid in an O&L context because that's one of the values to be retained. There's comment from Mr. Espy about this north-south division in the Cadrona Valley, which I've acknowledged in my report as well, and I agree with, but I think it's important to understand that both of these areas are in an O&L context, and there's agreement that the whole valley itself south is an O&L. And so there's values and landscape character and all the rest of it that comes with that. So it's not so one's better than the other, but both O&L. So they need to be considered in that light. And those values, all those values are valid for this site. There was comment that the recommendations of my report have been incorporated into this amended proposal. Just to highlight, those recommendations were only for lots 3 in section 8 of that original proposal. So it was only a 2-lot development. There was no intent for those conditions to apply to a 5-lot subdivision.
Sorry, say that again, Mr. Denny. Was there an original proposal before the 5 lot one?
Oh, sorry. In my report, I guess my conclusion was that I thought two lot subdivision could be adapted in there, and I had and subject to that, these are the recommended conditions of consent. So it wasn't intended to apply to all 5 lots.
Oh, I see. So that was with the original plan,
Yes.
with what is now lot 1 and the old lot 3, which is now lot 4, sort of, well, roughly. Is that, hang on, we've got those somewhere, didn't we, Bob? So, yes, so it was lot, oh yes, lot 3, but it is actually right in front of us. Yeah.
Yeah, the lots on the valley floor have been shuffled around quite a bit.
Yes.
Yeah.
Just a quick comment on the proposed mitigation of planting to the rear lots, which is outside lot 1. It's kind of small and pocket planting. I don't think it really contributes to landscape values as such. It's kind of responsive to the lot sizes in a rural lifestyle land use rather than the broader landscape values. There was reference to association with the site with some of the other developments nearby in the Cadrona Township and the Mount Cadrona Station Special Zone, as teaching as sort of like a context analysis. To my mind, it kind of highlights the potential for cumulative effects of this development as a satellite to those areas. It's a more distant satellite, I guess you say, to the core areas of development, but it is a kind of almost a sprawling effect from that needs to be considered. So it's a cumulative effect rather than an ability that therefore there's already development here a little bit more would sit into that context. To my mind, it's actually, no, it's an adverse cumulative effect. So overall, given the changes that have been proposed, it's already reshuffling of a 5-lot subdivision. I think taking the lots, 2 of the lots off the hillside was good, but to my mind, the hillside lot is a no-go area. There should be no lots up there, and I've still got concerns about the amount of spread up that green valley there in terms of outside the node. There's an opportunity there with the existing established context to absorb some development there, but I think this is going too far. So my original assessment of effects doesn't really change to the amended proposal.
What are your final conclusions on lot 1?
Yeah. Well, I think originally it was intended to be a farm dwelling to service a larger lot. And I was, 2 minds about it. I was sitting on the fence, I guess you'd say, and I always thought it was a bit marginal because it is a bit offset from the key sort of core as such. So I still have concerns about it. I mean, in my original assessment, I kind of, I sort of thought it'd be okay because it is quite well screened from the road. But now it's a lifestyle lot rather than servicing a larger lot. But arguably he's got, it's touch and go in my mind, to be honest.
Right. Do you have any comments on, recall I asked Mr. Espy about the planting program, irrigation, matters like that. And it appears, as I said, from our visit out there, it did look like some of the trees were a wee bit, well, tired, or I'm quite looking for the right word here, but how practical do you think it will be to reinstate, to replace those in a sequential way, as suggested by Mr. Espy? They've disappeared.
Oh
no, they moved.
I mean, the Cadrona Valley is quite a bare landscape, and so, there's an ongoing problem throughout the district too in terms of irrigation, mitigation planting. And I think what we had started to experience in the last 10 years is that we're getting these quite intense dry spells, and that does have an impact on some planting. So irrigation is, I think, important, especially for mitigation planting. But also, you don't end up relying on irrigation long term because that's not sustainable. So it's down to plant selection, I think, and initial plant management. I think that you can achieve that on the site. In terms of replacement of the existing trees on site for visual mitigation, the big trees, those poplars are large. And to replace those, it's going to take a long, long time. Don't have much confidence in maintaining that level of mitigation if those trees are removed in a short to medium term. I think it's a long term thing there. It's given the age of them and because they're going to be close to houses, there's potential they may be removed. That's going to affect most lot two or most, I think. Once those trees are gone, that site will be quite clearly visible from the road, almost prominent.
Right. Thank you very much, Mr. Dean. I think you've covered everything that I wanted to raise. I guess just to go back over, so effectively what I'm hearing you saying, so correct me if I'm wrong, but if we go back to the original plan, I think you, from your original assessment, you were sort of, I think, comfortable with lot 3, the original lot 3 that is, because it was sort of tucked in behind, sort of off the underling road, sort of tucked into the toe of the hill. Lots 2, 4, and 5 that were on that stage on the hill were, I think you see the right paragraph, so we know what we're talking about. This is at paragraph 75 of your original report on, actually I haven't got any page numbers, but it was part of the section 42A report. Proposed lots 3 can be readily absorbed into the setting, but lots 2, 4, and 5 would exceed this threshold, and the platform within section 8, which is now lot 1, is on the margin of the threshold. So if we now go to the amended scheme plan, survey plan, how does that translate? I mean, are you in a position to say, to give a summary in respect of this amended subdivision plan?
Yeah, sure. So the new lot 1, which is the previous section 8,
yes,
consistent with what was originally proposed, they're not serving the larger lot, it's pretty small lot. Yes, I think that can be accommodated in there. I think we can deal with that one.
Yes.
And then there's a lot where there's a small yard currently, which is now lot 4. So that's, to me, that's right at the core of that node of trees and existing buildings. So that can be absorbed into it as well. Lot 3 is you start, you're outside that node, you're into new territory, open terrain and such. That gets a bit more difficult. But lot 5, I think, it's a stretch. So, and then lot 2, I've never been split off on that hillside. That's something that can absorb that type of development on that slope. So to my mind, I think you could get lot 1, 4, and 3 with some amendments to some of the landscaping and conditions of consent comfortably into that site, but lots 5 and 2 be more difficult. So the dwelling of lot 5 would, to my mind, replace lot 3. So lot 3 become the balanced lot.
Right. Yes, I see. Yeah.
So you retain the
So you're effectively saying that. So your assessment of effectively the node in terms of what could be accommodated would be limited to that, and that would sort of be a cluster.
Yeah.
With the existing building, and then lot 1 to the side. Yeah.
So in other words, to draw the cluster quite tightly, but also presumably with it, so the lots are large enough so you don't run into sort of issues of neighbour type amenity.
I don't think neighbour amenity is that relevant. All the effects on the landscape from this development. is trying to use the existing opportunity of the mature trees and existing tracks and structures that are around that node. That's the opportunity that's available for this development. And I think it has been used to a pretty good degree to some extent. Once you get outside that, into the open terrain, and that's one of the key values of the ONL, it's this open character, sense of spaciousness, and the sense of very few buildings once you get out beyond these little pocket nodes. This is starting to encroach outside that, so I think that's having an impact on landscape values.
Okay, understand.
No, that's very clear. Thank you.
Thank you. I have no further questions.
No, that's all from me. Thanks.
So, Mr. Lees.
Yes. That was a lot of the things I wanted to talk about, sort of touched on throughout the day. I'll go through and clarify some points before I open myself up. I sort of agree with Mr. Denny about the adjacent road reserve. I think this morning it was brushed over. I think I acknowledge that it's not used currently, but the fact that it extends beyond the entire site, dissects the Skifield Road and goes into Mount Cadrona Village, I think it does provide an opportunity for future use, whether that be pedestrians or cycleways, I'm not sure, but it's a likelihood that someone like the Trails Trust might want to use that. Mr. Vivian was correct in acknowledging that the PDP now provides for permitted building within building platforms. So Mr. Todd was correct that under the old ODP regime it required a control activity, but given we're now assessing this under the PDP, which is operative due to appeals being resolved, we need to anticipate that each one of those proposed building platforms could have, as much development as the district plan would provide for. And the fact that the applicants have removed or volunteered bulk location and design conditions, I mean, you've sort of got to anticipate what's the maximum possible building that could be there as a permitted activity that the subdivision would provide for. So I think we need to be wary of that.
I wish it doesn't sound like a broken record, just to make sure I'm understanding you correctly. So I think it's the same as Mr. Vivian. If this building platform is approved, you can build as a right on it, subject to any conditions that might be attached to this consent in terms of height, colour, etc.
And standards, and standards in the PDP. Where are those standards actually?
They're just a bit further below the starting rules and the chapter of the rules. So chapter 21's got
21
locations and colours.
Yeah.
Okay.
And that's now that. So that was the latest Environment Court decision and resolved those appeals, didn't it?
Yeah. So I think the only outstanding appeal on any standards at all is one in relation to ground floor area. So it's currently at 500 metres squared, and the appeal is seeking to reduce it to 350. But beyond that one particular standard, everything else is fully operative.
Oh, really? So it's so the 500 might go to 350.
Yes. Otherwise, the PDP is resolved in that respect.
So that's the only outstanding matter now.
In terms of rule triggers for building a house on the platform, yes.
Okay, thanks.
What happens then? Does it become? I should know the answer to this because I did the consent years ago with if it's more than 500, it becomes is it restricted discretionary or discretionary?
I have to.
Don't worry, I'll be able to go look at my notes on that. It's not material to this, but at 350 is if that comes in that's getting to be quite a small dwelling for what would be standard in this district.
Yeah.
For these kinds of blocks.
Mr. Vivian was also correct acknowledging under the old ODP, if you didn't create a platform in every section, it was a non-complying activity. Yes. Under the PDP, you must create a building platform in every residential section. But if you're creating sections for other uses like agriculture or farming, they don't require a building platform.
Okay.
So by placing a platform in our balance lot, it sort of provides for an anticipated residential activity, in my opinion. I think one of the key, I think we're all in agreement, there's a little node here, and that node can absorb some development. But I think the node is traditionally made up of a farming character. And by creating this many lots with building platforms, I think that can change to a residential character, which concerns me at the scale proposed. But But I do acknowledge, sort of everyone said, that there is capacity to have a few sections in there with buildings that could be absorbed. Regarding most of the stuff before lunch, I agree that the transport and servicing matters are of no major concern. I think there's a feasible solution for each platform in that respect. I'm not forgetting our Section 106 considerations. The potential flooding hazard was a minor concern, but I think it could probably be resolved with some additional information from the applicant side. What the flooding hazard is and how to mitigate it. I'm sure something like a minor floor level or a finished floor level could probably resolve any hazard concerns. And I had some, I think the key issue is I had some reservations around Mr. SP's comments about thresholds. I think this is going to bubble down to what's an acceptable threshold for development. I think as it currently stands, the additional 5 platforms will probably be on that, based on some of the findings from Mr. Denny in relation to effects on landscape character. I think those policies we talked about this morning in Section 6, half of the policy and a key part of it is about what is reasonably difficult to see. But the other half of that relates to landscape character, trying to ensure that, what's the word, policy, the landscape values are protected. So I think aside from the reasonably difficult to see matter, I think we need to ensure that our O&L values are protected. I'm not sure that's entirely done with this much encroachment beyond the existing node. And I guess lastly, I'd just like to acknowledge, thank you to Mr. Todd for offering to circulate our landscape priority findings. So to confirm, those will be notified next Thursday on the 30th of June. And the findings within, I've only read the draft version that was circulated to council, and I'm told the final version won't be too different to what we're looking at. They go on to sort of acknowledge how important the openness is throughout the valley, but they also identify that there are these nodes of development around the valley floor that are constrained by topography or vegetation and could contain some built forms. So I guess that's something we've all sort of agreed on. But then it also touches on that there are concerns about cumulative effects associated with each development near the Cadrona village and Mount Cadrona station. So I think we need to be cautious here too about potential cumulative effects of excess development down the valley. I guess in a general sense, to conclude, I think although the proposal's been shuffled around a bit, I think that the general findings in my 42A are largely still applicable to what we're looking at.
I'll just start with the initial question. Twice in the last month, as a hearings or being a member of a hearings panel, we've been caught out quite badly in one case by an environment court decision or something similar coming out, which you weren't aware of at the time of the hearing and weren't aware of until later, but which, if it comes out prior to the hearing closing, can put us in the most invidious position. Now, I've found myself in that position twice recently. I know the court's doing its job in issuing decisions. Now, with these priority areas, and given the time frame probable to issuing this decision, what's your expectation as to when that might be publicly notified? Is it likely to happen in the next 2 months?
So I'm led to believe these priority areas will be notified on the 30th of June, which is 1 week today, next Thursday.
Okay, so that will affect us, won't it?
Yes, I guess if the hearing's not closed by next Thursday, that will become another matter, which I guess could get some consideration. But as Craig noted, it's not been through that public submission process yet, so it's by no means final.
I don't know, there's a waiting issue there, but something you might like to think about as well, Mr. Todd, because yeah, the other one we got was an environment court decision, which of course is quite a different animal, but on one application, we were quite unaware the decision had come out and we were forced to start scrambling to change the decision.
We're all struggling with that.
Yeah.
But yes, as Mr. Neve notes, and that's consistent with my understanding, that the priority is to be notified next week. We're not going to have the answer for some time because there's going to be consultation, and then I'm not even sure after the consultation where that leaves us in terms of finalising those priority areas. Are there going to be further submissions, further evidence, etc., before the Environment Court? So I think you're right. To the extent that it identifies values, it's only a matter of weight that can be given, because it's similar to a plan being notified, a proposed plan or plan change being notified. At the time of notification, we've only got one side of the story, and that's the council's position. It doesn't necessarily reflect where we might end up with.
Okay. The other question I had, Mr. Neve, is a boring question I always ask, and that is, are there any disputes between yourself and Mr. Vivian as to the identification of the non-compliances?
I think all of those listed by 42A were accurate. I don't think the amended proposal has raised any new non-compliances. So.
Any other, so that we can rely on that as an accurate identification of all those that are relevant?
Yes. Yes.
Okay.
That's helpful. Thank you.
I guess one final point, as always, I'd like to clarify, if the Commission is of their mind to grant consent, we'd be more than happy to work with the applicant side to try and get a complete set of conditions. So I think that's some way off.
Yes. Yes. No, we were going to actually request that. So thank you for offering. That would be very helpful.
No.
I just have one sort of question of substance really to explore, Stephen. This is the your conclusion that, and Mr. Todd has alluded to this, that the proposal is contrary to the objectives and policies at 6.3, or the relevant ones at 6.3.3. And given the conversation and the evidence today, is that still your view? And this is page 29 of the report.
Contrary is a very harsh word, but I think in a general sense, potentially, yes. I think if we're still looking at that platform up on the ridge and the extent of encroachment beyond the node, I think it does detract from the ONL somewhat.
Okay, thank you very much. I have no further questions. We've covered a lot of ground. All right, thank you. So, Mr. Todd, back to you in terms of where you would like to take us next. I'm assuming you want to do your reply in writing.
Yes, I think there's a few things that you've asked me to address, so I think I should do that.
And given the state of health of everybody, is probably you might want a little bit of time to do that.
Well, yes and no. I've got one. As I said, I have another hearing early next week, and then I'm away for 5 days the following weekend to Australia. So it'll be the week after that, I guess, that I can get this to you. I'll try and get it earlier, but I can't promise it, to be honest.
So is that the week of the, let's get my diary up here. Oops. So would that be
the week of the 11th?
Okay, the week of the 11th. All right. So do you want to nominate a day? I know that just makes it easier for.
Yeah, well, let's say the 13th. 13th,
okay. And it would be really appreciated as well if the applicant would work with council to come up with an agreed set of conditions,
right? Yes.
During that period as well, to be available on the 13th. So. And then following that, if we require any further information, we will obviously put that request in writing to you, just depending on what comes out of the.
Just in relation to a matter raised by Mr. Neve, it appears that there may be an amended ONL document to go out rather than the one that went to the council. It might have been amended since then. I haven't seen that. I've only got the ones from the council agenda. If Mr. Neve has got something, or we simply wait till they're notified on the 30th and I just give you a copy of the notified one.
Okay, that
would work.
Yes.
I've already submitted to Trish a plan which shows or a map which shows the extent of the pastoral lease.
Yes, thank you. We've got that. Yes.
Oh, you've got that already? Is that
just on there? Can I just clarify? So is the pastoral lease? Is it all on the
eastern side?
Eastern side of Cadrona Road. So there's nothing. Is there nothing on the other side of the road?
It's on the western side of. Sorry, it's on the.
Yes, it will be the western side of the road.
The western side of Cadrona Road. There's nothing on the Cadrona River side of the road, as I understand it.
Okay, great, thank you. That's really helpful. Thank you. Okay. All right. Well, is there anything else anyone?
That was it. Thank you.
Okay. All right. Well, thank you. Thank you very much, everyone, and especially for bearing with us with COVID, and I know I've had COVID, so I know how horrible it is. So I definitely would not have been attending a hearing while I had it. So you've done incredibly well. Really appreciate it, and look forward to receiving the closing submissions and the agreed conditions. And so I will just formally adjourn the hearing at this stage. Thank you.
Thank you all.